Good afternoon, everyone. My name is Yuval Shani from Hebrew University, and I'm very happy to launch the 15th annual Minerva conference on IHL. This is the first online conference that we have had in the series, and we hope that we will be able to make this lemon into lemonade, that is, engage new speakers and audiences who couldn't have come physically to Jerusalem. Still, we do hope that next year we are able to return to on-site conferencing, or at least to have the option of doing so. And I thank you for joining us today. As many of you know, Minerva is Israel's principal academic center for human rights research and study. It is centered at the Hebrew University of Jerusalem, and it focuses on a multiplicity of issues such as internalizing Israel's international human rights obligations through dialogues between government, civil society, and academia around reporting to human rights treaty bodies, advancing education and research in the field of transitional justice, including in and around Jerusalem, training young scholars in the field of human rights, and organizing a large number of academic events with a strong focus on promoting discourse around IHL. And indeed, this conference, which is, as I said, the 15th in its kind, is aimed at fostering a conversation among stakeholders in Israel and beyond, including government, civil society, academia, Israeli experts, non-Israeli experts, and to situate local legal discussions about IHL within a broader theoretical and practical context, bringing in insights from other regions of the world and other branches of international law, as well as new developments in legal doctrine and theory into the local conversation. We believe that this year's conference is a particularly good example of a theme which raises many practical issues in the Palestinian-Israeli context, such as prison visits, collective measures or collective punishments, search for remains, burial of the dead, etc., which we believe would benefit from broad conceptualization as involving the rights of indirect victims, that is, mostly relatives of prisoners, of the wounded and the dead, and of civilian victims. But we also perhaps think that within this concept of indirect victims, one could also include those who find themselves in broader circles of impact of armed conflict. Now, these are difficult issues that raise complex doctrinal and theoretical questions, such as who is a victim, whether the notion of indirect victim has any particular currency within IHL, how are the rights and interests of indirect victims factored in, for instance, in proportionality analysis, and what would be their implications for any remedial or procedural obligations. We hope that the proceedings in the next 3 days will help us to get a better grasp of such questions, as well as other questions, and to provide, as I said before, the local conversation about some particular manifestation of the issue with a critical perspective through which we can review and evaluate current state and non-state practice in this region, but also in other regions of the world. Now, I would like to note in this regard that many of the questions relating to indirect victims also arise in other contexts, namely in other branches of international law that overlap partly with IHL. For instance, in international criminal law, the issue of the status of indirect victims has arisen in proceedings before the ICC concerning the conditions for obtaining victim status. And it also is raised within human rights law, where cases before human rights courts and human rights committees that involve serious violations of human rights, such as enforced disappearances or extrajudicial executions, also raise concerns about the suffering of relatives of those who have suffered the primary violation. And those sufferings are often conceptualized as independent human rights violations, for instance, of family members or other relatives for which reparations are due. And here again, difficult questions arise as to what are the outer limits of the concept of indirect victims. What is the level of proximity in time? And what is the level of proximity in the relationship that is required to recognize someone as an indirect relative? And what type of harms can and should be compensated or provided reparation for instance, is the family life, the right to a family life of the indirect victim, an independent right that could be advocated? So we will be proceeding in the next 3 days in what is to a large extent still uncharted territory of IHL and other branches of law. But fortunately, we have assembled here a very strong group of experts with significant practical and academic experience, some of whom bring new and brilliant ideas to the table, and many of whom bring a lot of experience and a lot of thinking about these issues, to discuss multiple aspects of the law governing the treatment of indirect victims under IHL. Before ceding the floor to the first panel, which will be chaired by Professor Gloria Gaioli, and will deal with the broader question of indirect victims under IHL and IHRL, human rights law, I would like to thank the Minerva Center for all the efforts they have undertaken in connection with the organization of this conference under very challenging conditions. I want to thank Danny Evron, Advocate Danny Evron, the indefatigable executive director of Minerva, who has personally accompanied with me all the 15 conferences. As well as Anat Mishali, who has been our right-hand assistant, I think, in all of these 15 conferences as well. I also want to thank Dr. Renat Albin, the academic director of Minerva, for her support, as well as Professor Tomer Brody, the outgoing academic director. I want to thank Liana Bernstein, our digital media assistant, and Edna Sastiel, who handles all budgetary matters. And I want to acknowledge the contribution of the academic conference for this committee, which included, alongside Danny, Tomer, and myself, also Professor Yael Ronen, who is a part of Minerva and also part of the Israel Law Review, that is going to carry a symposium issue with some of the articles presented in this conference. Also serving on the conference committee were Maya Karen Abraham, Shlomit Stein, and Karen Lerner from the Tel Aviv delegation of the ICRC to Israel and the occupied territories, who have helped us develop the themes for the conference. Finally, I want to thank all the speakers in this conference who have submitted papers and those who have agreed to chair sessions for their contribution. I thank you, the audience, for joining us, and I wish us all a very successful 3 days. I now turn the floor to Professor Gloria Gaioli.
Thank you very much, Professor Shani. Good afternoon, everyone. First of all, I would like to thank the organizers, the Minerva Center for Human Rights and the Hebrew University of Jerusalem, for having invited me to participate in this 15th annual Minerva conference on IHL. I'm really, truly honored. I'm also very happy to chair the first panel on indirect victims under IHL and human rights law. We could even add under international criminal law, because both of the contributions deal actually with international crimes. So when we look at the notion of indirect victims under IHL and human rights law, we can think that this is a quite mysterious notion in the sense that in the Geneva Conventions, in the additional protocols, and in most human rights treaties, we don't find a proper definition of that term. However, there are some key documents. An important document that I would like to mention in particular is the 2005 Basic Principles and Guidelines on the right to a remedy and reparation for victims of gross violations of international human rights law and serious violations of IHL. So this document includes a reference to the term of victim that includes indirect victims. So notably, it mentions that victims include the immediate family or dependents of the direct victim and persons who have suffered harm in intervening to assist victims in distress or to prevent victimization. So this is just one example. With the presentation that we will have from Patrick and Grazina, we will see that the importance of recognizing the harm suffered by indirect victims, traditionally relatives, family members, is well recognized in international law, in jurisprudence, be it in international criminal law, IHL, and human rights law. A typical example being the right of families in relation to missing persons and enforced disappearances. So when I read the two contributions yesterday of our young scholars, I was very impressed by the high level of the contributions, the numerous original ideas that were proposed. And so I thought to myself, okay, let's try to find what are the key legal questions, the key questions that are being addressed in these two contributions. And so I devised 4 questions that I think are going to guide our discussion today. So the first question that is being addressed is who are indirect victims of IHL and human rights violations? Should indirect victims cover only family members? And then who can be considered as part of a family then? Should this approach be considered as too formalistic? And should indirect victims be identified based on the special bonds between direct and indirect victims of the harm suffered? Should witnesses to crimes be included? And what about those who tried to help direct victims? What about the broader communities? Should they be included also as indirect victims? And lastly, is the notion of indirect victim even relevant when it comes to enforced disappearances? Because we know that withholding information about the missing person is part and parcel of the crime of enforced disappearances. So that's for the first key question with the sub-questions. Now let me turn to the second broadcast question I think we are going to discuss. So my second question is, what are the types of harms that affect indirect victims? Should it be only psychological harms? Should economic harm be taken into account? What type of nexus between the harm suffered and the initial crime should we have? Is there a gradation of harm? Is it useful to have a gradation of harm? Now let me turn to the third set of questions. So the broad third question is the following. What are the legal consequences of the characterization of indirect victims from the perspective of international criminal law in particular? What about the participation in court proceedings? What about beneficiaries of reparations? How far are indirect victims considered as beneficiaries? More broadly, does the existence of indirect victims have an impact on the punishment of a person found responsible of an international crime? Or should we consider that the number of indirect victims should be considered as an aggravating circumstance? So these questions will be in particular tackled by Patrick. And then the last set of questions is in relation to missing persons and enforced disappearances. So in relation to missing and disappeared persons, what is the scope of the rights of families of missing persons? Is there only a right to know the fate of relatives, which you find in Article 32 of Additional Protocol 1? Or is there also a right to be informed of the progresses in the search of the missing persons? Is there a right to have a clarification of the legal status of a missing person through a declaration of absence or a declaration of death? Is there a right of families to assistance, benefits, and reparation or compensation? And lastly, how are IHL and human rights obligations regarding missing, disappeared persons actually implemented by states at the domestic level? This set of questions will be addressed particularly by Grazina, while the first set of questions, I think, is addressed to both of you, Patrick and Grazina. So now, to address all these questions, we have two brilliant young scholars with us. First, Dr. Grazina Baranovska. She's assistant professor at the Institute of Law Studies of the Polish Academy of Sciences. She's also currently leading a 3-year project on state obligations with regard to missing and disappeared persons under international law, which is funded by the Polish National Science Center. She wrote a book entitled Rights of Families of Disappeared Persons, How International Bodies Address the Needs of Families of Disappeared Persons in Europe. This book is forthcoming with Intersensia in 2021. I will buy it, I promise. I'm really interested in reading it. Then we have Patrick Gaka, who is a PhD candidate at the University of Warsaw in Poland. Patrick is in the process of finishing his doctoral thesis, which is titled Status of Victims in International Criminal Law, a Systematic Analysis. He's a visiting researcher at the Center for International Criminal Justice, Vrije University, Amsterdam in the Netherlands, and a senior research associate in public international law and policy group. Now, regarding the order of presentation, since Patrick is going to address the definition of indirect victims, I suggest that we start with you, Patrick, and then Grazina will address the issue from the perspective of the families of missing persons, which will constitute also a nice segue with the second session, which is focusing on two specific contexts in relation to missing persons. So both of you have 15 minutes. I will stop you after 15 minutes to make sure that we have sufficient time for Q&A. So I hope you will understand that I will have to cut you after 15 minutes if you have not finished yet. So let's start with Patrick. Patrick, you have the floor.
Thank you very much. Good afternoon. In this presentation, I would like to provide you with a summary of the main points which I raised in my paper titled The Concept of Indirect Victimhood from the Perspective of Punitive and Reparative International Justice. And I situate my remarks in the context of international criminal law. So the paper that I submitted is written not just in an analytical, but also, I should admit, in a kind of revisionist vein. Because my objective was not only to demonstrate how indirect victimhood has been treated by international criminal tribunals in the case law, but also to express my dissatisfaction with it and to suggest some changes for the future. So I should start by saying that indirect victimhood has been addressed by various international and hybrid criminal tribunals in their case law. These tribunals have done so either directly, that is by granting indirect victims the right to reparations, or indirectly, that is by referring to indirect victims in their reasoning, for instance, at the sentencing stage of proceedings. In addition, indirect victimhood has provided grants for the victim participation in international criminal proceedings. So as the things stand at the moment, indirect victimhood is discernible in both spheres of substantive and procedural international criminal law. Now, having stated that, in my view, the phenomenon of indirect victimhood still remains relatively under-examined as far as its conceptual foundations are concerned. I believe that it would be too rapid, too quick to assume that indirect victimhood is indeed a justified concept, given that given its current scope, right, and that it does not constitute any prejudice to the rights of the accused party that is often forgotten when we talk about indirect victimhood or the scope of victimhood more generally. So essentially, my submission is that the concept of indirect victimhood should be recalibrated. And in my further remarks, I shall explain why I think so by briefly addressing seven different points which I raised in the paper. I will do so in two parts. First, I shall introduce the theoretical model on which the paper rests. And second, I shall argue that the concept of indirect victimhood in international criminal law is both too narrow and too broad in various respects. So in terms of the theoretical model, I argue that in order to understand the scope of indirect victimhood, and in order to offer any critical reflection on indirect victimhood, it is necessary to take a step back and to focus on the source of indirect victimhood, namely on an act of victimization. We cannot understand the nature of victimhood without talking about victimization first. And under my account, victimization can be defined as a way of looking at the crime phenomenon from the victim's perspective. And victimhood reflects the status that the relevant entity, for instance, a human being, gains or is granted once an act of victimization takes place. So now let me address my first point, which concerns the relationship between victimization and criminality. According to the standard approach, victimhood is the result of an act of victimization. And if that is so, then every act of victimization by definition creates a victim. But in my paper, I submit that this is not necessarily so because of the distinction between factual and normative victimization. In other words, not every crime has by definition a victimizing nature. And we can give an example of the so-called victimless crimes. Apart from that, some acts of factual victimization, which may seem to be normatively relevant, will not be recognized as such if the defendant is capable of raising valid defenses, either justifying or excusing his behavior. What this means is that while victimization and criminality may and usually do overlap, they are not identical in every single case. They are not, in other words, always the two sides of the same coin. Now, the second point that I'd like to address concerns an internal structure of victimhood. In contrast to direct victimhood, which features only one source of victimization, namely the crime, indirect victimhood has two separate foundations, the remote and the proximate one. The remote source of indirect victimhood is the crime, an act of victimization itself. And the proximate or the close one is a harm sustained by a direct victim. In other words, indirect victimhood involves victimization of a direct victim with whom an indirect victim is in a normative or less frequently a factual relationship. And to put it briefly, it could be said that indirect victims suffer from international crimes because of the suffering of direct victims. This determination brings me to the third point, that is to an internal structure of victimization. I submit that victimization can take either a direct or an indirect form. Let's focus on direct victimization first. Direct victimization occurs only when victims' interests are directly infringed by the criminal act. For instance, when a person is raped, their sexual autonomy is directly violated. Similarly, when a human being is murdered, the resulting harm of death is strictly correlated to the protected interest of a deceased person, namely his or her right to life. This, in my view, attests to a direct link between direct victimization and direct victimhood. And on this understanding, rape and murder are examples of direct victimization, and rape and murder victims are consequently direct victims of these offenses. Indirect victimization, on the other hand, relates to the phenomenon whereby the crime does not directly violate protected interests of individual victims. But those affected by such an offense can still be regarded as direct victims because their harm lies in the crime and not in the suffering of other people. To visualize the point, in the paper, I mentioned several different crimes. For instance, the crime of aggression, environmental offenses, or cultural heritage destruction. These crimes are directed at predominantly collective interests, but if they are committed, they may no doubt impact individual human beings as well. So I don't think it is particularly contentious to say that, for instance, the population of the attacked victim state is affected by the crime of aggression, Let's take an example of the Crimea and the Ukrainian population living in Crimea. Similarly, when a person loses his or her job because of, for instance, the cultural heritage destruction, as was the case in the case of Almaty before the International Criminal Court, I think it is justified to claim that this person has been affected by this offense. Had it not been for this particular crime, this person would most likely still have a job in the mausoleum. Several mausoleums were destroyed in this particular case. As long as the concept of victimhood rests on the notion of harm and the binding standards of causality are met, I think it is conceivable to conclude that people may be harmed by offenses such as the crime of aggression, destruction of cultural heritage, or environmental offenses. Still, given that these crimes do not have as their main objective the protection of individual persons' financial and personal well-being, the distinction can and should be drawn between this form of victimization and the one stemming from rape or murder that I mentioned before. And if that distinction is correct, then I think it could be argued that those affected by, for instance, the crime of aggression or cultural heritage destruction are in fact indirectly and not directly victimized. And this leads me to my fourth point. I think we should pose the following question. How can this theory of direct and indirect victimization be translated into the distinction between direct and indirect victimhood? It is my firm belief that at the moment, the distinction between direct and indirect victimhood is not properly reflected in the source of harm and its connection to the victimizing act. First, we should note that direct victimhood may stem either from direct or indirect victimization, which I admit is controversial in itself, but unfortunately I don't have time to address this issue here as well. What this particular correlation demonstrates is that direct victimhood was designed as a broad and capacious concept. But importantly for us today, the fact that direct victimhood is a capacious concept has a direct bearing on the relationship between victimization and indirect victimhood as well. Indirect victimhood, after all, is premised on the factual and normative nexus between an alleged direct victim and his or her relatives, alleged indirect victims. The factual nexus is reflected in a causal connection, given that an indirect victim's harm must stem from a direct victim's harm. The normative nexus, in turn, requires there to be a family or, much less often, another similar link between direct and indirect victims. In consequence, since direct victims may be directly or indirectly victimized by international crimes, the same two sources of victimization can form a remote source of indirect victims' victimization. In the paper, I argue that this is incorrect, right? That this is incorrect. I don't agree with that. Why? Because in effect, the concept of indirect victimhood becomes, in my view, too broad and too remotely linked to the crime and its offender. Let me explain. To demonstrate the difference between direct and indirect victimization, I refer to the crime of rape and cultural heritage destruction. Against this backdrop, I believe it could be argued that whilst in the former case of the crime of rape, the nexus between direct victimization and suffering of indirect victims is indeed strong, for instance, family members of a rape victim. In the latter case of cultural heritage destruction and other similar forms of indirect victimization, the link is indeed too remote and too fragile. For instance, the indirect victims suffering from a direct victim's psychological harm sustained as a result of their cultural heritage destruction. Now, this leads me to the view that indirect victimhood should not be treated as a general concept of the same almost limitless character as direct victimhood, premised on the notion of harm, no doubt is. I argue that the concept of indirect victimhood should be limited only to those offenses which by their very definition directly target individual goods and interests of victims, for instance, murder or rape. indirect victimhood, in other words, should be considered normatively relevant only when resulting from direct acts of victimization. Under my fifth point, I would like to pose the following question. Who should be considered an indirect victim? This question concerns the problem as to which relationship should be subsumed under the category of indirect victimhood. The International Criminal Court and the Special Tribunal for Lebanon seem to follow a very conservative approach, according to which only family members of direct victims may claim to have been indirect victims of crimes committed against or to the detriment of their next of kin. In the paper, however, I defend the view that this is an overly formalistic and this time too narrow a view. In practice, it is no doubt possible that one may share very close bonds of friendship or even love with those who are not legally family members of the direct victim. And if indirect victim is indeed justified, a concept, it seems unfair to preclude non-family members from being recognized as indirect victims. And this is precisely where, in my view, the concept of indirect victimhood, at least before the ICC, is at the moment too narrow. So it is too broad and too narrow at the same time. Now, the sixth point that I addressed in the paper concerns the harm typology in relation to indirect victimhood. So the question that I posed in the paper is, should every type of harm be equally relevant for the recognition of indirect victimhood? I think that first it should be briefly explained that according to the ICC, there are three types of harm: psychological, physical, and material. In the paper, I made a provisional suggestion that only if alleged indirect victims can demonstrate that they have suffered psychological harm, should their indirect victimhood be recognized as such. Physical harms seem to be precluded from the scope of indirect victimhood by its very definition. And as regards material harm, it seems more justified to defend the view that immediate family members of direct victims shall act on direct victims' behalf in such circumstances, rather than as individual indirect victims themselves. I am aware that this is a very controversial view, but I'm still ready to defend it. And now finally, my last point, my seventh point that I address in the paper, is the following question. What should be the role of indirect victimhood with respect to punitive and reparative international criminal justice? So in the paper, I demonstrate in some detail by conducting the case law survey that indirect victimhood is relevant in both aforementioned spheres of punitive and reparative justice. This means that as the things stand at the moment, indirect victims may claim reparations for the suffered harm, at least before the ICC. And apart from that, indirect victims' suffering has also been considered by international criminal tribunals at the sentencing stage of proceedings. Given this binary role of indirect victimhood in the sphere of substantive justice, I should only like to put into the question the practice of affording any weight to indirect victimhood as regards the punitive dimension of justice. So under my account, international criminal tribunals should not pay any attention at all to the fact that families of direct victims have suffered harm. To my mind, this practice leads to an overly extensive attribution of remote consequences to an offender for the determination of his or her sentence. It may even eventuate in unjust results. So my view is that within the confines of international criminal justice, the role of indirect victims should be recognized solely in relation to the sphere of reparative justice, and the concept of indirect victimhood should be accordingly recalibrated, as I said at the beginning, and according to the two accusations, if I may say so, that I phrased in my paper, namely that the concept is both too broad and too narrow. And with that, I would like to finish my presentation. Thank you very much.
Congratulations, Patrick, and thank you very much for this thorough and thoughtful presentation. I enjoyed reading your paper a lot. It was very conceptual, theoretical, but at the same time, you included many examples of jurisprudence in your paper, and that was quite useful to understand your reasoning. I liked also the fact that in your presentation, you present from the beginning your position, and that I think is something that you could also integrate in your paper, because your opinion on the situation comes at the end of the paper, in the conclusion. And so when we read the conclusion, I was thrilled to see your opinion on the various jurisprudence, but I think you can already insert that before in your paper. Before turning to Grazina, may I ask you 2 or 3 questions of clarification? So in your contribution, you explained that there may be different legal consequences of the notion of indirect victims in relation to the participation in the proceedings, the punishment, or reparations. So my question to you is, should the notion of indirect victims as such necessarily be the same in relation to these different legal consequences? Could we imagine a definition of indirect victims which would actually differ depending on the legal consequences? Then I can ask you the 2 other questions, and then you decide the order to what you want which one you prefer to address. My second question is, to what extent does the notion of indirect victim vary depending on the type of crime? So did you see, when you analyze the jurisprudence, any difference depending on whether you're dealing with war crimes, crimes against humanity, acts of genocide? Is the approach always the same? And my last question to you is that you explain in your contribution that different international criminal courts and tribunals have different approaches regarding the notion of indirect victims. So from a policy perspective, what are the pros and cons of expanding the notion of indirect victims, as I understand you suggest? Thanks.
Thank you.
Would you like to address some of these questions now?
Shall I answer now? I don't know. It's I'm ready to reply to these questions, but I don't know if there are any questions from the audience. So
we will take the questions from the audience after the presentation by Grazina.
Right. So shall I address now?
If you prefer, we can go back to them after the presentation of Grazina, as you prefer.
That would be perfect. I need to think about the second one especially.
Great. So Grazina, you have the floor.
Okay, so I have a PowerPoint presentation.
Excellent.
And I will see how that works.
Normally you can share screen.
Yes, that's what I'm doing right now. Okay, how does it go? Do you see it?
Yes.
Okay, perfect. So I need to time myself. Okay, so thank you very much for the kind introduction. I will be talking about missing persons, and the main question that I'm trying to answer during those 15 minutes is to see how states implement IHL rules. And to do that, I will start with briefly introducing terminology, and then IHL rules, as well as rules applying to forcibly disappeared persons, so to the enforced disappearances that have already been mentioned in the introduction. And the main part of the paper is implementation of states, how I approach that, I will explain a bit more once I start this section. So missing persons is not a defined term, and it's used by different actors in different ways. And here in the broadest way, that's the red circle that I had used here, is how the ICRC approaches missing persons, that is everyone that is unaccounted for. And it encompasses also how missing persons are understood under IHL treaties, that is those that went missing during armed conflict. Of course, it's not defined in IHL, but that's how IHL treaties apply the term missing persons. And there's some overlap between missing persons in IHL and enforced disappearances, that is those disappearances that occurred with state involvement. But not every case will fit those. However, every case of enforced disappearances and missing persons IHL treaties will be covered by the missing persons understanding of the ICRC. A short comment on indirect victims. I do not think that using indirect victims is useful with regard to, in particular, enforced disappearances, because everyone that suffered in the effect of an enforced disappearance is a victim of an enforced disappearance per se. So there's no legal difference to be made. But also with regard to missing person, I would be very cautious to use the term indirect victims with regard to the family, because of the effect the missing or disappearance has on the families. And withholding the information or not giving information to families will always make this effect stronger or more difficult. From the point of view of the documents that I was analyzing, this is actually not a highly relevant point, because the two terms direct and indirect victims do not really appear. They appeared in two legislation, and I wanted to show one of them as they're particularly interesting. That is a reparation law from Peru from 2005, which distinguished three different types of victims. So it's families of disappeared or deceased, direct victims, and indirect victims. And well, I'm not sure whether that's really a useful way to approach it. It shows that really families of disappeared persons are a different category because of the effect it has on the family life as well. So now moving on to rules under IHL, there are clear rules resulting from the Geneva Convention. So persons have to be prevented from going missing. This is very strong in all four of them. The search for missing persons is actually less developed in the conventions, and families are not provided specific rights. Here, IHL customary law is much stronger. There's a prohibition of enforced disappearance, an obligation to respect family life and account for missing persons, as well as provide family members with information on their fate. And that also results from Protocol Additional 1, which is kind of the key IHL provision with regard to missing persons, Article 32 to 34. It starts with the famous right of families to know the fate of their relatives. And the scope of this right of families is debated and it's not clear. However, there are some really clear rights that can be read out of Article 32 to 34. So there's clearly a right to receive information about missing persons when their fate has been established, as well as to receive access to grave sites if the missing person has died. So that there's no doubt about that. Then there's some rights that are missing kind of from those articles. And I wanted to approach in my presentation today, in particular, highlight two. So, I will be highlighting mostly the first part. So there's no right to any additional measures that would make daily life easier for families. So a declaration of absence, about which we will hear more about during next panel in the context of Sri Lanka, as well as any additional assistance or benefits. And there's also no information on the progress of the search. So now moving on to families of forcibly disappeared persons, so to the International Human Rights Law framework. I'm mostly talking about the convention that came into force in 2010, but the rights of families have actually been developed in 2 decades upcoming to the convention in international case law, so mostly by the Inter-American Court of Human Rights, but also by the Human Rights Committee, on a lesser extent by the European Court of Human Rights. So how is a victim understood? As I said, a victim is any individual who has suffered harm as a direct result of an enforced disappearance. So here you can see that the differentiating between direct and indirect victim in case of this human rights violation seems to be irrelevant. And victims have particular rights according to the convention and to jurisprudence. And I want to highlight 3 rights. So first, to know the truth about the circumstances posed as a result of the investigation and the fate of the person. And I highlighted those parts that are not present in the IHL rules presented a minute ago. Then there's the right to reparation and compensation, as well as to regulate the legal situation of forcibly disappeared persons. And the convention clearly talks about social welfare, financial matters, family law, property rights. So it's really easy to think about what kind of regulation and why it's necessary. So clearly there's more right for families of forcibly disappeared persons than for family of persons missing due to armed conflict. And there might be many reasons for that. I just want to flag 3. And so first, there's the time factor. the convention came into force many decades after the Geneva Conventions and an additional protocol, while the notion of victims and who is considered victims and what rights of victims have substantially developed over the time. Secondly, enforced disappearances are human rights violations, why missing persons under IHL might be missing without any wrong conduct by the state. And that justifies clearly stronger obligation by the state with regard to enforced disappearances. So in particular, reparation and compensation are clearly an obligation with regard to enforced disappearances. And thirdly, families are assumed under IHL, families of missing persons, to be in another state than the missing person. So that's why the obligation are not really toward making the everyday life of the family easier. So there are clear differences why there's such a differentiation in the rights provided. Now, looking on the second part of my presentation, so the implementation of IHL. So what I did, I took the database provided by the ICRC, the National Implementation of IHL, and I looked at the acts that were provided in the database. I choose the database for two reasons. Firstly, of course, it's not exhaustive, but it's a very comprehensive list of acts. It's 36 states and it's 100 laws that are listed with regard to missing persons. I did not look at court decisions that were listed in the database. And secondly, maybe even more importantly, those acts can be considered as those that are most likely to follow the IHL approach. It's a database of how states adopt IHL. So it's a very great database to make broader conclusions with regard to applying IHL. So some very general remarks. The acts are very, very differentiated in nature. And so there are specific laws, but also implementation in civil codes or criminal codes. A substantial part of the acts refers specifically to enforced disappearances, and the majority of examples come from South America and Europe. And South America is in so far important that it's the hub where the laws with regard to enforced disappearances have been developed. So it really shows that rights are brought forward by of missing persons by the fight against enforced disappearances. And I will try to approach three questions. Firstly, who is considered a missing person under each law? And approaching that question allows to test whether states approach the term missing person in a way that IHL treaties apply it or the ICRC. And secondly and thirdly, those are the rights of families that are not provided for an IHL treaty. So regulating the legal status of the missing person, is it regulated and how? And thirdly, have family members rights to any material benefit? So I was looking very broadly at any form of support whatsoever. Starting with the first question, who are the missing in the law? So the very first obvious conclusions is that most of the laws are not limited to persons that go missing because of armed conflict. However, when they are, so those laws that do deal with armed conflict apply to armed conflict that are limited to certain conflicts. So here I show Bosnia and Herzegovina and Spain. There are other examples as well, or even more limited, so limited to enforced disappearances within certain contexts, within certain conflicts or times. And that might seem, and very often is, normatively neutral, but in certain cases that can lead to or can result from explicit or aimed limitation from a certain group of people. And in my paper, I mentioned Cyprus. And we will hear more about Cyprus and the international aspect in the following panel. The Republic of Cyprus adopted a definition of missing persons that it concerned times and not ethnic divisions. It actually factually excluded Turkish Cypriots from the definition. So that is something that needs to be looked into when we see that they are limited by time. And then there are other examples applying missing persons to other groups of people. So, for example, there are laws from the US which complain missing persons are missing members of the armed forces. A very interesting example of our Azerbaijani law, which includes missing persons under the so-called martyrs. And those are only those that went missing on the grounds of military operations. So that's an IHL perspective, clearly, and are considered dead. So that's more limited than just missing persons. So moving on to the second question, how is the legal status of a missing person regulated? And looking at the laws, two forms can be distinguished. So first, a declaration of absence, and secondly, a declaration of death. Exploring such a practice precedes actually Geneva Conventions. There's an example of an act from Belgium that applies to World War II and soldiers that went missing during World War II or persons that went missing in concentration camps. And the declaration of absence is in the majority of laws from South America. And in the majority of those laws, there's after a certain time, there's the presumption of death. So there's a change of the categorization, first absence and then death. There are a number, but not many laws that have only a declaration of death without the declaration of absence. And while there's no treaty law that clearly requires states to establish a declaration of absence, there are strong recommendations for states to do that. So it has been stated by the ICRC, and even which recommends a declaration of absence, and the UN Human Rights Committee has more strongly said that there should be no declaration of death as long as the investigation on the fate of the missing person are ongoing. So there are some limitations, and this also looking at legislation, this can actually be seen as a rising standard, this declaration of absence and not death. I wanted to look into one more thing, because families of missing persons might be interested in obtaining the declaration of absence and not changing it into a declaration of death. At least some of them, and I wanted to see whether some of the laws have such a possibility, and this is actually very rare. There is a prolonged declaration of absence. There's the possibility to prolong the status in a law on declaration of death in Sri Lanka, and more importantly, in Argentina, there is a status of absence due to enforced disappearance, and it has the same civil effect as an absence with presumption of death. So here there's no need nor incentive for either state authorities or the families to change their declaration of absence into a declaration of death. So now approaching the third question on any material support, and this can be basically divided into two groups of laws. So not all of the laws absolutely do provide benefits to families, but those that do can be divided into groups. So first are those laws that concern human rights violations, and those are predominantly enforced disappearances, but not only. And the forms of reparation and compensation are very different. Here is just one example in Colombia, which I found interesting, that it's only funeral and travel expenses. So that was not kind of what we would usually regard as compensation or reparation in a broader term. And the second group are laws that apply to missing persons from particular conflicts when the law takes a more humanitarian perspective. So it does not provide money or material support to all of the families, but to those that are in need. So this is, of course, phrased in different ways. For example, those that have been supported and so on. But generally speaking, that's a different perspective than the first group. So summing up, in my opinion, there are three main shortcomings with regard to families of missing persons that are addressed by the enforced disappearances framework. With regard to IHL implementations, states do not take either the IHL treaty law or ICRC approach to missing persons. There are various different approaches that we can see in the Act. Regulating the legal status is widespread, which is mostly done in the vast majority through a declaration of absence, but assistance to families is not as common, while it is recommended by some actors. So I would finish with stating that states predominantly go beyond their IHL obligation and provide families of missing persons with more rights than they are obliged to offer under IHL. Thank you.
Thank you very much, Grazina. So let me remind the audience that everyone can ask questions to our panelists through the Q&A function at the bottom of your screen. For the speakers and the commentators, they can also ask questions through the chat function. So Grazina, I liked reading your article very much. I think it was very clear, very well written. What I particularly appreciated was your methodology. which was to look at the implementation at the national level of the international law provisions that come from IHL and human rights law in relation to missing persons and persons who have disappeared. So on that basis, I appreciate also the fact that you concluded that somehow there is a convergence when you look at domestic law and how those international rules are being implemented. So that was, I think, one of the big highlights of your article. Now, as for Patrick, I have also a few questions for you. I will select just two so that we have time then for the Q&A with the other speakers and the audience. So my first question to you was in relation to the IHL right of families to know the fate of their relatives that can be found in Article 32 of Additional Protocol 1. In your article, you explained that it's not really a right, but just a guiding principle. So there is indeed a debate about whether it's a proper right or not, whether actually it's we should take into account the need of families or versus the rights of families. So can you tell us why your position is more on the guiding principle than when you looked at the implementation of those provisions at the domestic level? Did you reach the same conclusion that it's not really about a right, but just about a need? That's my first question. And then my second question is about the interplay between IHL and human rights law regarding enforced disappearances. I think in your article, you very well explained the differences of approach between IHL and human rights law. And then you very well explained that in terms of domestic implementation, there is a kind of convergence. But then my question to you is then, having analyzed the domestic practice and the implementation at the domestic level, what is your take on the actual interplay between IHL and human rights law? Do you have the impression that the rules on missing persons under IHL are still those we can find under the additional protocols? Or has the law evolved through human rights law and through domestic implementation? Thank you. Maybe we start with you, Grazina, if you agree, and then we come back to Patrick. All right? And then I take the questions from the speakers and the audience.
Okay, thank you. So that's a very on the spot. I will try to respond as good as I can. So yeah, with the debate. So my take on that is that when we, I think the reason why I'm more on the guiding principle side is because from a practical perspective, many of the family members will never know the fate of their relative. The states and organizations should be guided by their need and that the families want to know their fate and should do everything they can to provide them that information. But this right, from a practical perspective, for many people will not be able to be realized. And with regard to implementation, this is not something that really arises in any of the laws. There are some information, some laws that provide families with the right to access to information that are accessible or to investigation effects and so on, but not to right the right to know the fate, which is really practically difficult to perceive. So that is why my take on that debate is rather on that side. As for the interplay, so yes, I would say that states, in particular the rights of families, has been strongly influenced by research and development that has been done with regard to families of enforced disappeared persons, and there's clearly the law has evolved and the obligations are much stronger. However, because as I tried to show in my paper, in my presentation, as most states do not approach missing person in a way just for every missing person that went missing during armed conflict. It's really hard to state that there's a strong broadening of IHL. Because in fact, the broadening of rights of families is regarded with two very particular perspectives. So with human rights violation or to internal conflicts of very specific kinds. So I'm not sure whether we can go that far to say that that there's a general involvement in every case.
All right, thank you very much, Gadzina. Patrick, we go back to you then.
Right. Well, thank you very much for these questions. So I received 3 questions. Starting with the first one is, should the notion of indirect victimhood be different depending on the sphere to which it is applied? This is at least what I noted very quickly. Yes, I think there should be a distinction. If we talk about procedural justice, which I only very briefly mentioned in my paper, I think the distinction should be drawn between the situation in which an indirect victim, or at least we could say an alleged indirect victim, has been a witness to the crime. For instance, the family member witnessing the crime committed against his or her next of kin, and the situation in which an indirect victim learns after the fact that a person has been victimized, for instance, has been killed. So if we talk about those indirect victims that are direct witnesses of the crime, yes, their role is very important in these proceedings. Obviously, this is how international criminal tribunals can operate and prove the charges. The prosecution can prove the charges against the defendant. But if we talk about those who learn about victimization only afterwards, I think the only answer can be no, they have really no role in the proceedings unless we talk about a very specific role that victims may play before the International Criminal Court. And that is the situation in which they may appear in the capacity of a victim. This is Article 68.3 of the Rome Statute of the International Criminal Court. And in this capacity, they can obviously describe their feelings, their suffering, and this may have a very important effect on their well-being in the future. But I think the two situations should be distinguished. Now, with respect to substantive justice, my view is that within the domain of punitive justice, the fact that we have indirect victims and that people are affected by international crimes, the effects may be long-standing, widespread. These crimes may affect a large number of people, even from very remote places. I think we should be very careful because we talk about criminal proceedings. And what we don't want to do is to attribute crimes and consequences of crimes to an offender which are too distant from an act that is actually his or her act of victimization. I think another relevant argument for kind of constraining the scope of indirect victimhood within the domain of punitive justice is that usually the crime that is attributed to an offender, the offender is not a direct offender of this crime. So let's take an example of the case that was decided by the International Criminal Court, the case of Katanga. Katanga was a commander. He did not commit the crimes of rape, for instance, in Bogoro himself, which means that we first need to identify the direct offender in order to attribute these crimes to Katanga. And then if we think from the victim's perspective, we have a very specific situation which I think demonstrates the kind of relationality that applies in international criminal law. Namely, we've got an indirect offender, here it is Katanga. We've got a direct offender who is the person actually, for instance, raping women in Bogoro. Then we've got their crimes. We've got a direct victim, namely a raped person. And then we've got indirect victims, for instance, his or her family, right? So as you can see, the link is very weak already. And if we talk about crimes which are what I call the examples of indirect victimization, the link is even weaker, because there isn't even a direct link between the direct offender and the direct victim, because the good which is protected it does not belong to the victim, in a sense, to the future victim. So this is the reason why I think we should be very careful. I don't want to say that this applies to the whole area of international law, but I think in this particular case, international criminal law is specific. And in the domain of reparative justice, yes, obviously, indirect victimhood plays a significant role. And the main reason for that is because reparative justice is an example of something that is missing in international law, namely of international tort law. We don't have international tort law, but if we had, I believe we would apply similar standards as they are applied at the domestic level. So I think the best way of understanding what I'm trying to say is to think through the lens of domestic law and the distinction between crime and tort. International crimes can be crimes and torts at the same time. And the point I'm making is that within the domain of tort law, consequences matter. Harms lie at the very center of tort law. So obviously we should include all harms that meet the causal standard. And this is another problem that I very shortly address in this particular paper, namely the problem of causality. Because my view is that although we should recognize indirect victims' harms, damages, injuries, etc., only to the certain extent when the standard of causality is met. And the International Criminal Court adopts a very simple standard, namely the but-for test plus the proximate cause standard, which is again taken from the common law system. But if we go back to what I said just 2 minutes ago, namely the relationality, which is very often a very weak relationality between offenders and victims, this creates a problem because the standard of causation has to be proximate. And is it really proximate? So this is what International Criminal Court does not really want to address, kind of stipulating that if we've got a crime and we've got a harm stemming from it, there is a proximate standard. I think it's a very difficult oversimplification that the court is actually adopting in its jurisprudence. So I don't know if that answered your question, the first question, but I was trying to be as precise as I can at the moment. Now,
very helpful. Thank you. That was very helpful.
Thank you. Now, with respect to the second question, whether the approach should be different depending on the type of crime, or whether it has been different depending on the type of crime that the International Criminal Court or other international tribunals have addressed. I have to say, I haven't really looked at this problem from this perspective. So that's why I said that I need some time to think about it. But now, after a few minutes of thinking about this particular problem, I would say this, that within the domain of punitive justice, I wouldn't expect there to be any distinction, any difference. The reason for this is because the sentencing parts of judgments of ad hoc tribunals that I mentioned in the paper, or the sentencing judgments of the International Criminal Court are usually very short in comparison to the rest of the judgment. And I think it should be stated very clearly, although we are online, so I kind of fear to say this publicly, that they are very poorly reasoned. What the courts actually do is they adopt a copy-paste approach. And I examined all sentencing judgments of international criminal tribunals. So I can state that with some degree of certainty that this is what they actually do. And it is infuriating sometimes, I have to say. The reason is because we want to know the reasoning, but the reasoning is missing. And the court is basically saying, well, we've got the binding legal standards that apply to us, the statute, the rules of procedure and evidence, and all those tribunals draw inspiration from those documents, obviously, and they say, well, we should also consider consequential harms suffered by the victims, because this is what, for instance, Rule 145 of the Rules of Procedure and Evidence of the ICC provides for, that the court should also take notice of consequences of the crime. And the court does not distinguish between consequences of the harms suffered by direct victims and indirect victims. Another problem that is also not addressed by the ICC and other international tribunals is the distinction between conduct crimes and result crimes. And I think the distinction is very important, because within the structure of the result crime, the result is already the consequence of a consequence of a certain conduct of the offender, which means it has to be included in order to prove the crime and then to sentence the offender. But the same does not apply to conduct crimes, because they don't require any result to take place in order for an offender to be sentenced, in order to be convicted of a specific offense. So I think this element is also missing, and the court does not take any account of this distinction between conduct and result crimes. Now, turning to the third issue, namely my suggestion that indirect victimhood should be broadened. And although I was kind of expecting that I don't have much more time for my presentation, so I didn't want to go into details during the presentation itself, now I'd like to say that I fully support an approach that the Cambodia chambers have developed, and more precisely, the Supreme Court of the Supreme Court, which is the Court of Appeal with respect to Cambodia chambers. The decision that I discussed in detail in my draft paper, I think, is the best piece of writing in international criminal law on indirect victimhood more generally. Since I think it was issued in 2012, since then I haven't found any better reasoning with respect to indirect victimhood in international criminal law. And the reason why I fully support the approach of the Cambodia chambers is that they make it very clear that first, victimhood stems only from direct victimization. And this is my first point, namely that the concept of indirect victimhood as it is applied by the ICC is too broad, because it doesn't differentiate between direct and indirect victimization. It's too broad. And the second point that the Supreme Court in Cambodia made was that not only family members, but also other people may be considered indirect victims. And the reason why I support this is because I think, what is the point of this overly formalistic approach? Only family members. The only argument for that, which supports this kind of limitation that I can find, lies in international human rights law. Because if we look into Article 23 of the International Covenant on Civil and Political Rights, Article 8 ECHR, Article 12 of the Human Rights 1948, Article 11.2 and 17 of the Inter-American Convention on Human Rights, this is where we will find references to family interest, right? To the fact that every person has the right to family and that family should be protected as the basic entity. This is the only kind of legal reference that I can find in international law for limiting it. But the fact that the family is protected, that does not mean that our close friends, our close relationships that we've got with other people shouldn't be protected. As long as those people who claim to have been indirect victims of the crime can provide valid evidence supporting the view that they have a very close bonds or very close relationship to a direct victim. So this is the reason. And the last remark, if I may, I would like to make is this. The courts, International Criminal Court and other international criminal tribunals have adopted certain presumptions, saying that, for instance, this is what the ICC did, saying family members do not have to provide any evidence that they have been indirect victims only because they are family members of the direct victim. right? So they don't need to provide any evidence that they have suffered any harm, which every victim in theory has to do, only because they are family members. And at the same time, we exclude people who might have been victimized, might have been harmed by the fact that a direct victim has been victimized, but we exclude them only because they are not family members. So I think there is like an internal inconsistency. And this is the reason why I decided to pursue this kind of reasoning that not only family members should be considered indirect victims as long as an applicant is able to corroborate his or her view that she or he has suffered harm resulting from direct victimization, from direct victimhood of a person. Thank you.
Excellent. Thank you very much, Patrick, for these detailed answers. Now let me take questions from our speakers and other panelists. So the first question comes from Professor Yuval Shani, and it's addressed to you, Patrick. So I read his question. My question is as follows, he says. The right to reparation under international human rights law assumes either violation of the first order rights of direct or indirect victim. What would you consider to be the first order international human rights law rights of indirect victims for which reparations are to be awarded? Do they potentially include all rights impacted by the direct harm? For example, the right to family life or economic well-being rights? And do you see a parallel first order right of indirect victims in IHL?
It's a very difficult question, I have to say, because I don't really know how to understand the concept of the first order rights. I don't know if it refers to the hierarchy of rights and to the this is the reason I don't know really what to say, because I don't really understand the notion of the first order right here.
Can we give the floor to Yuval? Is it possible? So that Yuval can further elaborate.
Thank you. Do you hear me?
Yes.
Yes. So a reparation is, one useful distinction in human rights law is between the first order or primary obligations or rights. That is the rights which are detailed in the European Convention or the ICPR or the other treaties, and then there is a right for a remedy in the case that the first order or primary right had been violated. So the question is, but in order to get to the reparation right, you have to first identify what has been the violation for which a reparation has been given. So if we are talking about the relative being merely a proxy for the, as you insinuated in your remarks, for the direct victim, so to speak, this is one thing. But I think there is a notion that the relative is in himself or herself is also a victim of a direct of a first order violation. That the conduct in question has either generated stuff inhumane is a form of inhumane treatment, or has violated a family right, or has violated in other contexts maybe right to standard of living, what have you. So I was interested to hear your thoughts about whether there are limits to what rights could be invoked in order to bring into play, so to speak, the reparation duties, and whether IHL has a similar concept that the relative actually has rights which are independently protected than the rights of the, so to speak, direct victim.
May I quickly ask a follow-up question? So I don't know if we may turn it into a discussion, but let's take an Article 6 and 8 of the European Convention on Human Rights. Article 6, the right to a fair trial, and Article 8, the right to family life. So if the right to a family life is violated, my understanding is that because, for instance, the right to a fair trial maybe is a better example here, because the person is not is charged with a crime, but then the trial is not conducted without undue delay. And this might be a violation of the right to a fair trial. So under this understanding, under this provision, I would say that there is only a direct victim of this crime, namely the person that has suffered prejudice because, for instance, the trial took place over the period of 10 years. And I don't really see any place for the family members, as long as a direct victim may claim compensation, may apply to the court, and may say that, for instance, my rights have been violated under the Article 6 of the European Convention. But then if we think about the right to life, for instance, Article 2 of the European Convention, and if we say that the right to life has been violated, that the person, for instance, has been killed by state agents, then obviously I can see the ground for granting family members of a direct victim of this particular violation the right to apply to the European Court of Human Rights and, for instance, to claim compensation for that violation. But it is an open question, in my view, whether the family members actually apply on their own behalf or on the behalf of a direct victim. Because this is a distinction I also make in the paper between those who actually claim reparations on their own behalf as indirect victims and those family members who apply to the court, but they are not granted any autonomous status, but only in a sense they act as intermediaries between the direct victim, who is, for instance, who was killed, and the court. And they claim compensation in a sense on his or her behalf, because obviously this person no longer can do it. If we look into the jurisprudence of the European Court of Human Rights, and obviously I'm not that familiar with this jurisprudence as I am with the ICC's jurisprudence, we can find in these cases many examples of the situation in which family members apply to the court because a direct victim of human rights violation is unable to do so. And I would say that I would say that the scope of reparation and the scope of the recognition of indirect victimhood in international human rights law is the same. The reason for this being that I don't know any case from the European Court of Human Rights in which the court would say, we accept your application, but we accept your application, we find a violation of the convention, but we don't think you deserve to receive any compensation or reparations more broadly. I think all of this kind of falls under the same confines. And if somebody is okay, now I need to. Okay, so I think I tried to respond, and I don't see any ground for a separate application. Thank you.
All right, thank you very much, Patrick. And now I have a question for Grazina from Healy Mudrick Evan Ken. Here is the question. Do you think that rights of families of missing persons under IHL, so Article 32 AP1, are subsidiary to the rights of states? That is, if there is a conflict of interest, for example, it seems that the state's interests, parties to the conflict, will have to prevail. Also, it was mentioned in the ICSC commentary on the protocol that Article 32 of AP1 is more of a moral than a legal provision. What are your thoughts about that? So it's a kind of follow-up question regarding my previous question. And so do you see potential conflicts of interests or rights between rights of states and the rights of families?
Yes. Well, so yeah, the short answer is yes. And there are actually a lot of conflict of interests that can arise in the subject that I was presenting, that I'm researching, and that can be the different interest of a state and the family. It can be the different interest of two different states, because different family members that will ask for the access to that person might be in different states that could under IHL ask for that. And I mean, those are theoretical questions, of course, but that's something that is possible. Then there can be the conflict of interest between the missing person and his or her family. And here it seems that most actors are clear that the right to privacy of the missing person should prevail. So if the missing person does not want his or her fate to be revealed to the family or to the state, then that should prevail. And that's ICRC's approach and case law. But Argentina, in the end, took a different regard with regard to the right to truth. So the kind of the right of the family to know prevailed over the right of the missing person to not reveal the fate. So it's many different approaches that can be different. And I think, well, obviously every situation has to be analyzed separately, but yes, in short, I would say that the state's right would prevail. And I have a question whether I could shortly talk about family rights and to kind of dig into the discussion that was going on a minute ago. Would that be okay?
Sure.
So I'm not really sure whether seeing the source of the problematic phrase of family rights and kind of indirect, direct victims is really in international human rights law, because in many situations you would see that the approach toward family is actually very, very broad, containing also persons that are not under legal or blood ties with the person. So, for example, persons that have been living with the person that was, say, the direct victim. So you would see many case law examples where actually that really goes beyond what family understands. And also the ICRC commentary to Additional Protocol 1, while there's clearly family mentioned in the protocol, states that it's also personal and emotional ties. So not only blood and legal ties. So what I'm thinking is whether it's really that worth kind of saying that the notion of family is should be criticized and not just accept that it's understood by most bodies broader than just legal or blood ties. So that would be my take. And then with compensation, that was already brought up in the discussion that there's many families of disappeared persons, but also families that have been given back remains that were mutilated, were found to be victims of inhuman treatment. So in that sense, I mean, there's no differentiation by the European Court of Human Rights whether they are then direct or indirect victims, but they were certainly not victims of physical harm. So they were kind of, their loved one was somehow mutilated, for example, and they were found because of that to be victims of inhuman treatment. So I think that's also kind of goes further than what we've discussed. Thank you.
All right, thank you very much, Gredzina. I have one last question from Mia Swart for Patrick. You do not want to compensate family members as indirect victims. How do you measure remoteness then? What if a parent lost a child? How can there be a stronger bond proximity than this? And when does the line between victimhood and indirect victimhood dissolve? So I think it's a question for clarification.
Yes, well, thank you for this question. I do not argue that family members cannot claim compensation as indirect victims. So that's the only clarification. And I certainly do agree that it's very difficult to think of a stronger bond that's between parents and their child that is killed. So I think in this particular case, there would be no problem to ascertain that parents of a direct victim can claim compensation from an offender. And just to give you one example of that, the case of Lubanga, families and parents of child soldiers were recognized as indirect victims in the proceedings before the court. Thank you.
All right, thank you very much. So I think that we are reaching the end of this session. I don't want to take more time. I come from Switzerland, so I should be precise, and we have already taken 5 more minutes. So I thank you very much for your excellent presentations and for the stimulating Q&A. Thank you.
Thank you very much.
Okay, thank you very much, everyone. I think we can start this second panel of the day. And thank you very much to the conference organizers for having invited me. It's really an honor to share this session on missing persons, and even better on two examples that I know well, Sri Lanka and Cyprus. I would like to remind the audience that you can send written questions using the Q&A function at the bottom of your screens. Before introducing our panelists and giving them the floor, I would like to make a few remarks. We see that every day people go missing the world over because of armed conflicts, violence, disasters, or in the context of migration. And that countless of families are searching for their relatives or are waiting for answers. To give you an example, today, more or less 140,000 persons are registered with the ICRC as missing worldwide. And this figure is far from representing the true extent of this problem. And I would like to say that today, due to the current pandemic situation, we are or we have been separated from our families. I think that more than ever, we have realized in the past few months how keeping in contact with our families and how family unity is such an important and essential part of our lives. Now, imagine a mother, a father, a son, or a daughter deprived of any possibility of contacting his family, or a mother, a father, a son, or a daughter not knowing what has happened to their loved ones, living every day, wondering, searching, waiting, rebounding between despair and hope for 1, 2, 10 years, for a lifetime. In this process, families, of course, in addition of wanting to know what has happened to their relatives, face enormous needs that derive from having a missing relative. And these needs can be from a legal nature, can be administrative, economic, and also psychological and psychosocial. I think we can rightly say that the anguish of families searching for a missing person does not decrease with the passage of time, and that missing persons shape the history of families, communities, and societies profoundly. Also, something important to highlight is that such unresolved consequences of conflict, for example, that stretch over decades, can hamper the prospects of any reconciliation and peace. And I would like to share with you two stories, personal stories from Sri Lanka and Cyprus. When I was working in Sri Lanka, 2 years ago, we organized a meeting with families in the north. And then a mother and a father came to the meeting with a plastic folder with papers and photos. Photos of their son, who went missing more or less 15 years ago, photos alone, photos together as a family, and papers of all the démarches they had undertaken as a family to find answers. This father and this mother, during the meeting, they were holding the folder very close to their hearts, like they were somehow holding their son. And this folder was that, the hope that one day maybe they will find an answer and they will find him. Then also 2 years ago, I had the opportunity to visit the Committee on Missing Persons in Cyprus. And we met as well with some families. And there was a gentleman whose father went missing during the war, and his remains have not been found yet. This gentleman explained to us that, of course, he's waiting for answers. He wants to know where his father is. And that for many years, his mother kept all of his father's clothes and belongings intact in the same place in their house. And that she cooked for him every day. In case he comes back, he might be hungry. We need to be ready, she said. And these, for me, are stories of families that we can find everywhere in the world, in Latin America, in Europe, in Africa, in the Middle East, or in Asia. In the previous panel, a presentation was made on the legal framework protecting missing persons and their families under IHL and IHRL. I think we can rightly say that the international legal framework, along with its implementation, is the basis for the search of the missing and for upholding at the national level the rights and the needs of the families. The examples that will be presented by our two speakers today are a good reflection of that precisely, of how the international legal framework can be implemented at the national level, but also of the many challenges that may arise from implementing these frameworks when working on the search of the missing and addressing the different needs and rights of the families. From a very important moment, which is the moment a state takes the decision to address this issue. And we will see through the experiences that our panelists will present how important this element is. So without further ado, I would like to introduce our two panelists. First, we have Dr. Nasia Hadji-Georgiou, who is an assistant professor in human rights and transitional justice at the University of Central Lancashire. Nasia holds an LLB with first-class honors from the University College of London, an LLM from the University of Cambridge, and a PhD from King's College in London. She has been awarded the Graduate School Studentship from King's College in London, the Leventis Scholarship for Academic Excellence and Research Potential, and the Cyprus State Scholarship for Academic Excellence. She's currently heading two research projects, one funded by the International Peace Research Association Foundation, and the other one by the Hellenic Observatory of the London School of Economics. Nasia will be presenting her paper on Truth and Closure in a Frozen Conflict, an assessment of the Committee on Missing Persons in Cyprus, where she will shed light on the relationship between truth and closure by focusing on the experiences of families of those who went missing in Cyprus between 1963 and 1974. And then we will have as a panelist, Ms. Vishaka Vienayake, who is a PhD candidate at the McGill University, where she's also an O'Brien Fellow at the Center for Human Rights and Legal Pluralism. Vishaka completed her LLB with honors at the University of Colombo and obtained her LLM from the University of Michigan and Harvard, where she was a Fulbright Scholar and a Hugo Grotius Fellow. And Vishaka has also worked as a lecturer at the Department of Law in the University of Jaffna, and she was also an associate of the Legal Division of the ICRC in Geneva, and a legal advisor in the ICRC delegation in Sri Lanka, where I had the pleasure to work with her. And Vishaka will be presenting her paper on protecting rights of missing persons and their relatives through IHL and IHRL, a case study of Sri Lanka, where she will be discussing the situation and the process to find the missing persons in Sri Lanka, with a particular focus on the issue of the legal status of the missing. So without further ado, Nasia, please, you have the floor. Thank you very much.
Hi, everyone. Can I just check that you can hear me before I start talking? Okay, you can. Great. So, hi again. I'm here to talk to you about the Committee on Missing Persons in Cyprus, or the CMP, and the extent to which the truth it delivers contributes to feelings of closure among the relatives of missing persons. I will start by giving you some background information about the CMP and the way it operates. I will then briefly talk about the methodology we adopted and conclude with our key findings. In a nutshell, the findings are that the truth provided by the CMP can indeed lead to closure, as long as attention is paid to the way truth is delivered and to the type of truth that is being delivered. So starting with some background information about the CMP. The committee is a body that was established in order to locate, identify, and return to their families the remains of those who had gone missing in Cyprus between 1963 and 1974. The committee, unlike any other body on the island, is bicommunal, meaning that it is staffed and headed by Greek Cypriots and Turkish Cypriots who are working together in order to locate the missing from both communities. It was established in 1981, but it only became operational in 2006, and that's when it exhumed its first body. Since then, it has returned the remains of about half of Cyprus's 2,000 missing persons. The committee does not operate like a typical Truth and Reconciliation Commission, in that its focus is not the general public. Instead, it exclusively or almost exclusively focuses on the relatives of the missing. So what happens in practice is that the committee identifies someone, and a psychologist employed by the CMP arranges a meeting with the family, usually at the family's home, where he informs them of this. The family members are then given the opportunity to visit the CMP laboratory, where they can see the assembled skeleton or whatever is left of the assembled skeleton, and meet the scientists that worked on their case and ask them questions about their case. Immediately after, a funeral takes place, and that is the end of the process. In other words, the information that was used in order to identify the person and in order to locate the person cannot be used in any criminal prosecutions, and the perpetrators or alleged perpetrators who are enjoying an amnesty remain anonymous. The committee provides a pretty simple truth to the relatives. This is your person, and we can now definitively say that he will not be returning home. What we tried to assess in this paper is whether this truth contributes to feelings of closure among the family members. We did this by interviewing 34 key stakeholders from both sides of the Green Line, in other words, both Greek Cypriots and Turkish Cypriots. We interviewed 4 employees or ex-employees of the CMP, 2 journalists that have been following the committee's work for the last decades, and 28 family members. So the results. Most of the relatives stated that the return process indeed induced closure, and provided 2 main explanations for this. The first one was that the return of the body finally gave confirmation that the relative had passed away and allowed the grieving process to begin. Receiving the remains extinguished any hope that they were clinging on to and allowed them to mourn without feeling guilty that they had given up on their loved one prematurely. The confirmation of death was particularly impactful because of the way the CMP delivers the results, and in particular because of the fact that it allows the relatives to see the remains before the funeral. Some relatives explained that before visiting the CMP laboratory, they irrationally were expecting to see the person that had walked out of the house 50 or 60 years ago. This expectation was shattered in the most effective, albeit brutal way, when they saw a pile of bones rather than the person they were expecting to see. So equally impactful, in addition to the body, was the fact that the committee is returning not only the remains themselves, but also personal belongings of the person. So they are returning a cross that the person might have been wearing when he disappeared, his wedding ring, his car keys, his cigarettes that he might have been holding. All of this provides confirmation to the relatives, in addition to the DNA test, of course, that this is indeed their person. The second way in which the return of the body induces closure for the relatives is that it finally allows for the funeral to take place. Many relatives explained that the organization of the funeral helped them feel that they had completed a duty towards their family member. They were still profoundly sad about what had happened, but they had stopped feeling this ambiguous loss, and they were finally able to start living their lives again. Now, despite most interviewees agreeing that the CMP contributed to this sense of closure, all of them had serious complaints about how the CMP is operating. The first set of complaints concerned the way the CMP delivers the truth. On the one hand, they mentioned that there were massive delays in the CMP's process, as confirmed by the 25 years delay in locating and identifying the first missing person. This has three negative implications as far as the missing person's relatives are concerned. The first implication is that during this quarter of a century, memories faded, witnesses died, and large infrastructure projects were constructed on top of burial sites, which makes it impossible to locate all of the missing. The second implication is that relatives, mostly parents, but now increasingly also siblings and spouses, died before they could find out what had happened to their loved ones. One of the starkest illustrations of this is the inscription on the tombstone of the wife of a missing person that reads, "If you find my husband, please bury him next to me." The third negative implication of the delays is that many families found out what had happened to their loved one on their own, independently, and long before the committee had found out the same story. This meant that when the CMP eventually delivered the results, they were a lot less impactful than they would have been otherwise. It also created a sense among the relatives that the committee is simply not trying hard enough to do its job. So interview after interview, we were being told, if we managed to find out what happened to our missing person on our own with so few resources, why didn't the CMP do it before us? The second complaint that relates to the way in which the CMP delivers its results is the lack of transparency that characterizes its operations. Essentially, the only time that the CMP communicated with the relatives in this whole process was when their person was found. In the decades that preceded the announcement, no information, no updates had been provided at all. The relatives were totally in the dark. This lack of transparency undermined feelings of closure, again in three ways. First, it left many relatives feeling bitter that their pain had been exploited in public, but when they needed help in private, they were ignored. The second problem is that it created perceptions, whether these are accurate or not, I don't know, but the perceptions were nevertheless created, that some relatives were treated differently than others, and some relatives received priority over others, which created a sense of bitterness and again undermined feelings of closure. The third implication is a practical one, and it is that the lack of transparency hindered the flow of information from the relatives who were carrying out their own investigations to the CMP. So what happened in practice is that the committee interviewed relatives in order to find out everything they could about a particular missing person soon after it was established in the 1980s. At that time, people were still very reluctant to talk about what they knew. By the time the stories started being heard 10 or 15 years later, and the relatives had started getting a more accurate picture of what was happening, the committee had already closed its doors. And it was therefore increasingly difficult for that information to be communicated to the committee unless the committee also independently happened to stumble upon that information on its own. Now, if the first complaint of the interviews concerned the way in which the truth was being delivered, the second complaint had to do with the type of truth that was being delivered. The problem arises from the CMP's mandate. The CMP can determine whether the person is dead or alive, and in the former case, it can also provide an estimated time of death, but it cannot provide any more information than this. More crucially for the relatives, it cannot disclose the cause of death. Many relatives found this to be especially upsetting because, and I don't blame them for this, because they felt that they were once again robbed from the opportunity to find out the truth. So one relative commented, "Darkness everywhere," and that phrase, "unknown cause of death. Bodies perforated with bullets, and if I show you a death certificate, you will lose your mind. A bullet to the brain and unknown cause of death." This failure to provide the truth that the relatives were looking for, not just any truth, is tragic on a personal level, but it is also detrimental for the society as a whole, because the absence of closure can translate into a desire to seek revenge. So, for example, another interviewee told me the following: "I want perpetrators to feel the same way as the people who killed or tortured felt. I wish them all to die painfully. You can write this statement as it is." So to conclude, in a nutshell, the CMP has to a certain extent been successful. It has to a certain extent promoted closure for the relatives, and it is right that other societies in other post-conflict societies like Iraq, like Lebanon, like Sri Lanka are copying its procedures and practices. At the same time, however, concluding that truth leads to closure is an oversimplification. What we should be focusing on is the type of truth that is being delivered and the type of truth that can lead to closure, and how this truth is being delivered and how it can lead to closure. It is on these lessons that the societies seeking to learn from the Committee on Missing Persons in Cyprus should be focusing on. Thank you very much.
Thank you very much, Nasia, for your excellent presentation and overview of the paper. And I think you mentioned maybe two important elements from your paper and the research, the very field practical research you did in Cyprus, meeting with the families. And you really mentioned when the truth is delivered, and this was a key aspect for the CMP and for the families, and then the type of truth that is delivered. I guess that the example of the CMP is very interesting in the sense that, yes, you have in their mandate written that the CMP will not disclose information on the cause and the manner of death, but rather will just provide information to the relatives, as you mentioned. This is your relative, we have identified him, these are their belongings, to allow this process for the families. I have started to receive some questions, but I propose that we move to Vishaka's presentation, and then we open the session afterwards for questions for Nasia. I also have a couple of questions, but then we can discuss them later. Thank you again, Nasia. And Vishaka, please, you have the floor.
Right, thank you very much. Let me just try and share my screen here. Yeah. Is it sharing now? Yes?
Yes.
Yes.
Okay. I'm trying to make it, okay. Right. So as Jimena mentioned, I'm dealing with a case study of Sri Lanka on how the legal status of missing persons has been recognized there. And although there are several theoretical questions that I did think about while writing the paper, I'm particularly dealing this on a very advocacy level or a practical level. About how the certificate of absence can be used in Sri Lanka in order to hold the government accountable to search for the missing. Before going into my central thesis, I'd like to give a brief outline of what a certificate of absence is. As has been mentioned by Jimena as well as Nasia, there's The families of the missing face many challenges while they wait to hear about the missing person. And these can impact how they exercise their property rights, how whether they have custody to their children, and even whether a family member has the right to remarry. But in most cases, in order for, if the legal status of the missing person is not legally recognized, families are forced to not have access to these rights, or in some cases, they're compelled to apply for certificates of death. So what the certificate of absence does, it gives a legal document to the families, which enables them to have access to certain administrative processes, as well as property rights and other basic needs. And in Sri Lanka, the problem I identify is that with political regime changes, there's no consistent political will to search for the missing. And my proposal is that by interpreting certificates of absence through a human rights perspective, we can enhance the accountability on the government to search for the missing, as well as make rights of the missing and their families more enforceable. So I would like to give you a very brief overview of what has happened in terms of missing persons in Sri Lanka in the past decade. The majority of the missing persons cases stem from an armed conflict that began in 1983 between the state and a non-state armed group called the LTTE. And the armed conflict ended in 2009, but even a decade after the end of the armed conflict, there are still at least 16,000 missing persons remaining in Sri Lanka. Since the end of the armed conflict, there has been significant international pressure to set up transitional justice mechanisms, but these actually started manifesting with the political regime change in 2015, when the existing government was displaced, and there were several legislations that were enacted. One of the most important of these was the setting up of an Office on Missing Persons, which is an independent institution in charge of facilitating the right to know of the families, as well as other needs of the families. In addition to that, in 2018, there was the incorporation of the Enforced Disappearances Convention through legislation in Sri Lanka. But my paper primarily focuses on the Registration of Deaths Temporary Provisions Amendment Act, which changed. So before this law was passed, what the situation in Sri Lanka was that families had the option, if they wanted to apply for death certificates if a person has been missing for over a year in relation to the armed conflict. But in 2016, with this act, they were able to apply for certificates of absence, which recognize the legal status of the missing person, which enable the families to seek certain benefits from the government. Now, what is concerning for me is that since 2019, there has been a political regime change again, and the defense secretary at the time of the end of the war is now the current president, and his brother, who was at the time the president at the time of the end of the armed conflict, is now the prime minister. And in February, the president made a statement saying that the missing persons are actually dead, and therefore death certificates should be issued in their name. And this was made to the UN representatives. And the prime minister had made statements about overturning the Office on Missing Persons Act and the Enforced Disappearances Act, saying that these were measures taken due to international pressure. And the president's powers have been expanded with an amendment to the Constitution this October, and that can affect how commissioners are appointed to the Office on Missing Persons, making this process much more political than it was before. So, why do I say that the certificates of absence are important in this kind of volatile political context? Requiring families of the missing to obtain declarations of death can expose relatives, one, to re-victimization, and this can amount to cruel and degrading treatment prohibited both under International Humanitarian Law, under Common Article 3, and also international human rights law. Secondly, as was elaborated in the presentation before me, this deprives missing persons, the families, so it deprives all the missing persons of legal personality and can lead to the state not being held accountable to search for the missing. And once issued, the effects of the death certificate are very hard to reverse. So it is important that the certificate of absence is maintained within this context. But in Sri Lanka, the certificate of absence is merely a document catering to the needs of the families, and it doesn't cater to rights of the persons concerned. And the argument I'm trying to make in this paper is that this document should recognize rights of both missing persons as well as their families. And this can help the political interference into the certificate of absence to be understood as a violation of human rights rather than a mere political preference. So when you go into the missing persons' rights, I think it's absolutely necessary to go beyond international humanitarian law to international human rights law. This is because IHL does not expressly demand states to recognize the legal status of missing persons. In Article 32 of Additional Protocol 1, the missing persons issue primarily caters to the right to know of the families and not the missing person himself or herself. So in Sri Lanka, we have to acknowledge that the certificate of absence does provide a legal personality to missing persons, and that is a good thing. It should be appreciated, but this is very much family-centered. So the decision whether to apply, even to apply in the first place, or to maintain or continue to prolong the COA is the choice of the relatives. And the COA also grants control to the family over the missing person's property, finances, children, and this is done in the assumption that the families would exercise this power in good faith and in the best interest of the missing person. And let's say we can assume that even if they do exercise this power in the best interest of the missing person, as was mentioned in the previous presentation, there's a risk in making the issue of missing persons completely reliant on the families. This is because as time goes, families can, the importance that families give to this issue may recede, or the family members who are fighting for this, for the missing person or hoping them to come back may pass away. So the pressure that's put on the government from the family is not going to last for a long time and may recede with families themselves aging. So the argument is that the right of the missing person to have an investigation and for the search of the missing persons to happen, there needs to be accountability that is independent from the needs of the families. And international humanitarian law ensures this by recognizing that the missing person has in his or her own right a right to an effective investigation. Although this has been acknowledged in the context of enforced disappearances, there are human rights jurisprudence through these ECHR that also recognizes this as a part of right to life, which is common to all missing persons. And it can be argued that issuing death certificates for missing persons can also affect their equal protection before the law by creating a certain civil death where their presence legally is no longer acknowledged. When it comes to families of the missing, using a human rights law standpoint can enforce socio-economic rights of the families. And as we heard from Jimena, there are lots of challenges that families face in accessing services and needs. And in contexts such as Sri Lanka, where most of the missing persons are adult men, This is exacerbated because there's a patriarchal undertone to the legal framework, which makes it more difficult for families of the missing, which happen to be female-headed households, to have access to certain legal rights. And the certificate of absence is intended to address many of these concerns of families of the missing. But as it stands now, the law enabling the COA is temporary. So the extension of this act itself depends on a subjective assessment of the government as to whether the office, whether the concerns of missing persons are important enough to extend the legislation. And in the current political climate, we cannot take the government prioritizing the concerns of missing persons as, we cannot take that for granted. So what I argue is that by framing the issue from a human rights standpoint, if the government refuses to extend this act enabling COAs, it becomes a violation of the rights of the families. And this gives the families a legal tool to hold the government accountable to ensure that their rights are protected. So my argument is that the families of the missing who are made vulnerable due to the missing status of their loved one can be classified as a social group who deserves protection under the International Covenant on Economic, Social, and Cultural Rights. And if the denial to give them access to certain services by depriving them of a certificate of absence can be a violation of their right to social security, right to housing, right to family life. So the political interference of the COA becomes a legal violation and not merely something that the government has a discretion to exercise or prioritize based on their subjective assessment of how important the issue of the missing is. So finally, why do I advocate for an approach that incorporates both IHL and IHRL in this type of situation? Firstly, because international humanitarian law only caters for the right to know of the families, whereas international human rights law recognizes both the rights of missing persons and their families. And secondly, unlike Article 32 or the customary IHL, which doesn't carry with it an implementation mechanism, human rights law provides international monitoring and complaint mechanisms, especially to countries such as Sri Lanka, which have ratified most of the core international human rights law treaties. And from past experience, we know that international pressure has had a strong impact on how on the decision of the governments to enforce transitional justice mechanisms. Also at the national level, interpreting the COAs through a human rights perspective gives access to families to seek relief through constitutional protection of fundamental rights, as well as the national human rights institutions. So my argument to end is that where there is lack of political will, it's helpful to increase the agency of the families and the missing persons through an interpretation of the certificate of absence through a human rights framework. Thank you.
Thank you very much, Vishaka, for your intervention and for explaining as well the context of Sri Lanka, which has been, I would say, a very challenging one with a lot of positive and challenging changes over the past years. I think what you mentioned as well on how you would approach the issue between IHL and international human rights law, it's very interesting. And as well, I would like to highlight some of the challenges you mentioned in terms of the COA in Sri Lanka, where you have a law that it's of a temporary nature. Then you have as well the fact that families in Sri Lanka, like in many countries as well, the missing persons are often the breadwinners of the household. So it's mainly female-headed households who are left there to face all these administrative challenges and procedures, sometimes even just because of how societies are, without even having the possibility to accessing any of these measures that have been implemented at the national level. So I would like to open now the floor for questions. I already have a question for Nasia from Jeremy, who wants to know, he says, the CMP seems to be a remarkable example of transitional justice during ongoing conflict. In addition to closure, has the CMP contributed to peace building and or political reconciliation in North Cyprus? Thank you, Jeremy, for your question. And Nasia, you have the floor.
Thank you. Really, that's a great question. And it's actually so good that it's the second question of the two that we sought out to answer in the research project that this paper forms part of. So the first question we tried to assess was, how is the CMP doing as a humanitarian institution in terms of promoting closure? And the second question was, how is it doing as a peace-building institution in terms of promoting reconciliation between the two communities? While the answer for the first question was a guarded a guarded positive one, it's doing well subject to certain qualifications. The answer to the second question, is it an effective peace-building institution, has been a resounding no. So even though the committee itself advertises its work and markets its work as contributing to the building of peace in Cyprus, the relatives do not see it this way. They do not feel that what the committee is doing is promoting reconciliation in Cyprus. As to why that is the case, that really is subject to a wholly different presentation. I think in a nutshell is that it cannot be doing both. It's not, its mandate does not equip it to do both. It's just a humanitarian institution.
Yeah. Thank you very much, Nasia. And from my side as well, when reading your paper and now listening to your intervention, I had maybe two questions and one general comment. And my first question relates to what you explained, no, about how delivering the truth can achieve closure for families on the missing, with the challenges on when and the type of truth. And I was wondering whether maybe you would have any observations when it comes to when information should be provided to the families, at what stages of a process, of a search process, information should be provided to the families, and how. Knowing that, for example, yes, the search process starts when there is a list, you do an investigation process, then there is the whole scientific, anthropological, archaeological DNA analysis, then the corroboration of the information, then the confirmation of the identification, and then the answer to the family. So I was wondering whether you could maybe elaborate a little bit on that, on throughout this whole process, the whole search process, when information should be provided to the families, and how, knowing as well that every time information is provided to the families, it can create expectations, and then it can be also difficult to handle. So it's really, I would say, a balance that needs to be considered. So this would be my first question. And then maybe as well, just out of curiosity as well, maybe if you can mention as well why this delay between the moment that the committee was created and then the first exhumation that took place only in 2006. Yes. So I will let you answer these two questions. I will give my comment after, and then I will read another question that we have from the participants. Thank you very much.
Okay, so thank you for the first question is excellent. So it's definitely the case that it's not the case that the more information you give, the better, because indeed you create expectations and that can backfire. So to answer the question, how should information be delivered? I think that the committee could have adopted a multifaceted strategy. So they could have had private meetings with families in order to provide them information that is relevant to that particular family. And at the same time, they could also have public events, which they by and large did not have, in which they could give an overall assessment of how things are going with regards to their efforts to locate the missing persons. And in those meetings, they could ask for more information from the general public for further information. And it is these kinds of meetings that would have acted as an excellent peace building activity as well. They have not taken place at all. As far as I know, there have been one or two which relatives have described to be transformative for them, yet the CMP has not taken up that comment, has not repeated it further. The other thing that I would say about how information is to be shared is that the committee does not necessarily have to decide that on its own. So we could tell the families, we have information, and if you would like to know that information, feel free to contact us. It has not done that either. In fact, one of the relatives complained that in the 1990s, when he tried to get information about his father who was missing, the committee absolutely denied to share anything that they knew, because at the time it was their policy that they would not share information, even if they were directly asked by the relatives. And he had to take the case all the way up to the Attorney General of the Republic of Cyprus, who authorized the disclosure of evidence in this particular case. Since then, I know that the committee has started sharing information with relatives that are asking for it, but that is not mentioned anywhere in any of the leaflets of the CMP. So if you are an outspoken relative, a fairly well-connected relative, and you feel that you can ask, you will ask, and you will probably get some information. But if you're someone who is in need of information but doesn't know how to access it, the committee doesn't make it easy for you to get that. So that's with regards to the first question. And I will say that I think it depends from family to family, and also from family member to family member. So I know that some families have kind of designated a person within the family that will talk to the committee. And I guess it would make sense if the committee had a really good relationship with that one person, and then it's up to that one person to decide whether it would be helpful, for example, for his elderly parents to find out more, or whether it wouldn't be helpful. So I'm not advocating a paternalistic approach where the committee decides what is best for the relatives and tells them when it's best. So that's the first question. The second question, why was there a delay between 1981 and 2006? The answer to that is there was simply no political willingness on behalf of Greek Cypriots and Turkish Cypriots to cooperate. So for 25 years, they were negotiating bylaws as to if, I don't know, if equipment is going to arrive in Cyprus in order to start digging up people, is it going to arrive in the Republic of Cyprus, or is it going to arrive in the north of Cyprus, and what kind of, I don't know, what kind of documentation is needed for that equipment to get onto the island. So I think what they were trying to do was use the question of missing persons as a proxy to answer the bigger question of the conflict, which is who recognizes whom. that is still a problem. That is still something that hinders the committee's work. It's still very much there. And there have been complaints from almost all of the relatives that the reason some people are still not located is not because the CMP does not know where they are. It's because the two sides, the Greek Cypriot side and the Turkish Cypriot side, are playing quid pro quo. So I'm not going to tell you where the Turkish Cypriots are, even though we know where they are, say the Greek Cypriots, until you tell me where an equal number of Greek Cypriots are, which of course is a recipe for bad humanitarian outcomes.
Thank you very much, Nasia, for your answers. Maybe with regards to the first point, and the information to the families, I think I would add as well that these processes are so complex and scientific and difficult to understand that it's very important to ensure that in any state where there is such a process, to explain to the families well, no, what does it mean? What is an exhumation? What is an excavation? What is DNA? What is investigations? So that the families as well understand, I mean, from what is happening and what's going on. So I would also add that to the first point, and as you mentioned as well, the public events, sharing information, explaining, it's super important. Now we have a question from Professor Yuval Shani for both of you. He says, can you provide more details on whether there have been claims that the delay in the process of investigation is a separate human rights violation from the original disappearance/deprivation of life? Are there allegations in the context you study about discrimination in connection with the pace of investigation, prioritizing certain victims over others, and how compensations when such are awarded and calculated? So I will give the first floor to Vishaka, if it's okay to answer the question, and then Nasia, and then I'll come back with one question that I have for Vishaka. Thank you very much, Vishaka.
Right, okay, so what I can say is that there haven't been in Sri Lanka any domestic cases about the missing, how the search for the missing has been so far undergoing. At least from a human rights perspective, a fundamental guarantees perspective. But it has been recognized, at least in the case of unlawful detention, that it's a continuous violation. So for example, in Sri Lanka, to go before the fundamental rights jurisdiction, there's a time period. So it should be within a couple of months. But in the case of detention, you can, that time period doesn't apply because it's a continuing violation. And I think that kind of mirrors enforced disappearances crime as well, because international law recognizes this as a continuing violation, but this has not really come before courts in Sri Lanka, as far as I know. And with regard to the pace of investigation, this is interesting because at the point around 2016, when the transitional justice mechanisms were being drafted and consultations were being carried out in Sri Lanka, there was a huge debate about how to sequence transitional justice mechanisms. So which process should go first? Should it be truth and reconciliation mechanism, or should it be criminal investigations? But it was decided that the search for the missing should be, like, that was the first transitional justice mechanism that was set up in Sri Lanka, because there was a humanitarian angle to it, so it was less political and it was easier for country to get a political buy-in in this process as opposed to some of the other more politically contentious processes. Having said that, in terms of prioritizing how to sequence specific missing persons cases, with regard to this, the Office on Missing Persons Act in Sri Lanka gives discretion to the commissioners on how to prioritize cases. And there is no specific requirement to prioritize, for example, the people who complained first, or who went missing first. So they can make this decision, for example, based on a symbolic case, which has gained a lot of attention, or which might create less political controversies. So in that sense, it does give a lot of discretion, which may cause, I mean, I don't think this has happened at a, there hasn't been a wide allegations against the OMP yet. It just began working, but it does give discretion to the OMP on how to prioritize the cases that they investigate. Finally, about compensations being calculated. From financial point of view, families of the missing have been given 6,000 rupees allowance by the Office on Missing Persons, and this is simply like to access their basic needs, and it's not like a reparation, for example, for certain crime that is being committed. Although in Sri Lanka, when the reparations bill was being drafted, there was a lot of debate about who deserves financial compensation. For example, do members of the LTT, former members of the non-state armed group, and their families, would they receive financial compensation, and is that fair? So there were debates, larger debates, but not so much about actually catering to the humanitarian needs of the families of the missing. That hasn't created a lot of issues so far.
Thank you, Vishaka. Nazia, please.
Okay, so I detect 3 sub-questions within that one question. The first has to do with delays. There is a well-known ECHR case on the missing persons in Cyprus, Varnava against Turkey, Varnava and others against Turkey. In that case, the court, and I think Vishaka alluded to that case before, in that case, the ECHR recognized that there is a violation of the right to life of the missing person themselves, but there is also a violation of Article 3, the right to from torture and human degrading treatment for the family members. And that is what that case is most well known for. However, in the less important or the less well known part of the judgment is that the court in that case said that any other relatives in Cyprus who want to bring a case against Turkey were barred from doing that because they have waited too long in order to bring the case. So even though the disappearance of these persons is a continuous violation, basically what the court said is you should have realized by now that not enough is being done in order to find your relatives, and you should have brought a case already. And I think that is a bad judgment on behalf of the ECHR, because it penalizes the relatives for the delays of the CMP rather than actually considering it to be an even greater human rights violation, that the CMP has not done what it was supposed to do 25 years ago. There is a follow-up to that. So the relatives of missing persons are barred from accessing the ECHR due to delays they're barred from arguing a violation because the CMP has not identified their person, but they are not barred from arguing a slightly different argument, which is that if the CMP finds their person and the state refuses to prosecute, they have access to the court in that situation. But they only have access to the court in that situation for 6 months, and they have not been using it. I don't know whether I'm making sense. It's a very technical point. The second sub-question that we were asked was whether there is any discrimination with regards to who is being located and who is not. As far as I can tell, there isn't in Cyprus. The only complaints that I had, and they were consistent and very vocal, is that the CMP within its structures seems to be keen to only find a proportionate number of Greek Cypriots to Turkish Cypriots. So it's not keen to find too many Greek Cypriots and not find enough Turkish Cypriots. I think that boils down to a lack of trust between the two. If all Greek Cypriots are located, for example, there's not going to be enough reasons for Greek Cypriots to cooperate to locate the Turkish Cypriots. And finally, with regards to compensation, the CMP does not compensate the relatives at all. It's not within its mandate. There has been some compensation paid by the Republic of Cyprus and by the Turkish Republic of Northern Cyprus, the unrecognized entity in the north, but that is not part of what the CMP does. Those are independent processes.
Thank you very much, Nazia, for your answer. And maybe to the issue of the prioritization, I guess I would add that, I mean, based on different experiences from countries where you have search processes that are put in place to search for thousands and thousands of missing persons, inevitably as well, the work has to be organized and prioritized because a mechanism has to first put in place a very good technical process, and then has to be able as well to select cases that that can fit as well into how they advance as well in their work. And we see this very well. And then this, again, I will link this to the previous discussion on information to the families. This is very important as well to explain to the families that if a mechanism is put in place, then the mechanism, because of XYZ reasons, has decided to look into cases for the reasons that it will mention. It can be, for example, I've seen in some context in Latin America, because you have what they call easy cases in the sense that they have a lot of information and then the investigation is easy and they can move forward with that. Or you have examples as well where the case might be very important, sensible, symbolic, but to gather information on that case will take a lot of time and years. Now, maybe Vishaka, I would like to go back to your presentation and the discussion on the certificate of absence and really how such an instrument like a certificate of absence or a declaration of absence for those countries where it's through a judicial decision that you get this declaration can be a very important instrument to support the families in enforcing their rights and addressing their needs. And I wanted to ask you whether you could elaborate a little bit more on the challenges in the implementation, because I think also making the link with the first presentation where we talk about the international legal framework, then we have to implement passing laws, policies, but then there is a huge challenge after that, which is the practical application and implementation that sometimes can create as well a lot of burdens for the families. Over to you, and I invite everyone, either from the audience or the participants, to share any questions. Thank you.
Yeah, so in Sri Lanka's context, one of the main challenges has been the mixed messaging that has been given to families. The law itself is very complicated in how it determines whether to issue a certificate of absence, what type of evidence is required. The procedure itself is complicated, and it requires from the central government instructions to be issued to like village level, district level governmental authorities, and then for them to explain to the families how this process is done. And from my experiences with the families, a very heartbreaking finding was that when the families could apply for death certificates, they did apply for death certificates, and the reason for death was given as the person has been missing for over 1 year. And when the law was changed to enable them to apply for certificates of absence, they didn't realize that the previous document they received was a certificate of death. So like, but aren't you going to change this certificate to a certificate of absence? Like, no, this is not a certificate of death. Look, the reason, it says the reason is the person has disappeared. So they believe that the death certificate was a document that was evidence of missing status. So there is a lot of confusion within the families about the different kinds of documents. Secondly, another problem that practically was there was that once a certificate of death is issued, there are automatically legal implications to that. Succession rules apply, people get remarried, property gets distributed among the family. And then you're given this option to again say, no, he's not dead, the person is missing, but the consequences cannot be reversed. So these families are stuck in this situation. And the other thing is that for families, and we think of a family as a monolith, but there are different interests within the family. So there is a elder parent who wants for the person to be declared missing, but there are siblings, who want these property issues to be solved and to move on with their lives. There might be a spouse who wants to get remarried, and for that you might need a death certificate. So these issues, there are lots of clashing interests within the families, and that is again why I argue that it is not as simple as to say, oh, we are issuing a certificate of absence to the family, and then they will take care of the interests of the missing person. But the family doesn't share a common interest. And as the parent dies and the certificate of death absence may be in control of another person in the family, there are lots of practical concerns about how the missing person's rights can be addressed through this document.
Yes, thank you, Vishaka. Thank you very much for that. And I guess as well, what we see is that often those who are called upon by the law to apply these procedures, the district officer or a judge, they are not even aware of the existence as well of these pieces of legislation or these administrative decisions. So you may also have challenges when families, they come and they face, and this we've seen as well in different contexts, that the person who is supposed to give them the certificate of absence or take a decision, say, I'm not aware of this law, or also families, for example, and this is very important, families will take this certificate of absence or this declaration to a financial institution, to a bank. And then the financial institution often says that they don't accept that because it's not part of their financial regulations. So this to say as well, as you mentioned, Vishaka, that when we look into the needs of the families as such, it's really about understanding well all of these variety of needs and understanding well the frameworks that exist in a particular state to be able to address these very specific needs. I don't know if someone else has another question. I don't see any questions in the chat or in the Q&A. But then just before we end, I would like, again, maybe just to give you the floor to Nazia and Vishaka, if you have maybe a final remark before I close the session.
If I have a final remark is one that relates to comparison between different post-conflict societies, that it makes sense to assess one institution in order to see whether it can be copied or used as a model of good practice elsewhere. But at the same time, you have to be extremely careful in order to understand what you are superimposing the institution on. Otherwise, you risk creating results that you absolutely did not expect.
Thank you very much. And Vishaka?
Yeah, I would like to say that, well, when the transitional justice mechanisms were designed in Sri Lanka, there was political, to a certain extent, political will. And there was an understanding that these independent institutions would serve for the best interest of the families, that the government cares for this issue. What my concern, and part of the reason why I wrote this paper, is I'm very concerned by the wavering political interest right now in the country. And the assumptions that we had cannot be taken for granted anymore in going forward with transitional justice processes in Sri Lanka. And this is why I think we need to rethink advocacy tools that we have been using in Sri Lanka in terms of the missing, and go for a more rights-based approach where, you know, families and those affected directly have tools to directly claim for their rights rather than depend on the government's benevolence for these processes.
Thank you very much, Vishaka and Nancy. I think, I mean, this panel has been, in any case, very interesting for me, and listening to both of your experiences. Maybe as a final remark, I would add as well, here we are discussing two examples of a post-conflict or frozen conflict situation. So many years after the war ended, then the issue of the missing is being looked into. But I will also, I would like to end as well by arguing that even during armed conflict, no, it's very important that the situation as well of the missing is addressed by the parties, that proper information is collected, and that all the ground for any future clarification of the faith and whereabouts process is started from the beginning, from where the conflict starts, so that at the end of the day, you start taking early action to be able to address better the situation. And as well, because of the fact that the conflict is ongoing, that the needs of the families are still there, that people are going missing every day, and that these families should be provided with answers and with different types of support. So on that remark, I would like to thank both of you for your time, for the discussion that we have. It was very interesting for me. And so now, yes, thank you very much. And I would like to remind everyone that we will reconvene at 7 o'clock, so in half an hour, for the keynote lecture by Professor David Kretzmer. So looking forward to seeing all of you again in half an hour. Thank you very much, Vishaka and Nancy, again, and I hope to see you soon. Bye.
Bye.
Welcome to the keynote lecture by Professor David Kretzmer. The title of the lecture is Family Members in the Israel Supreme Court's Decision Relating to the Occupied Territories. David Kretzmer is a Professor Emeritus of International Law at the Hebrew University of Jerusalem. He has been a visiting professor at Columbia University, Tulane University, University of Southern California, and the Fletcher School of Tufts University. From 2006 to 2009, he was a professor of law at the University of Ulster, and until 2019, he was a professor of law at Sapir College in Sderot. David was a member of the UN Human Rights Committee between 1995 and 2002, serving as vice chairperson of the committee in 2001 and 2002. He is a commissioner of the International Commission of Jurists. In 1993, David founded the Center for Human Rights at the Hebrew University and served as its first academic director. In 1997 till 2000, he headed the Minerva Center for Human Rights of the Hebrew University and Tel Aviv University. Professor Kretzmer's main fields of research are constitutional law, human rights, and international humanitarian law. Among his several books, The Occupation of Justice, the Supreme Court of Israel and the Occupied Territories, first published in 2002, and a second expanded edition of this book, written together with Yael Ronen, will be published by OUP at the beginning of 2021. Besides his academic work, David has been active in NGO work. He was a founding member of the Association for Civil Rights in Israel and served as chair of its board. He's also a member and chair of the board of B'Tselem. Professor Kretzmer, you have the floor.
Thank you very much, Ayal. And good evening to all those participants who are in our part of the world. And may I say possibly good night to some people who are in other parts of the world. Good afternoon to people who are west of us. And it's a great honor and a great pleasure for me to speak to you at this conference this evening. The subject of my discussion is going to be somewhat different from the papers that we heard, the very interesting papers that we heard this afternoon. I'm going to be concentrating on decisions of one specific domestic court, of course, the Supreme Court of Israel, in its decisions relating to the occupied territories, which involve family members. And before relating to the subject itself, I'm going to have to say some things about the Supreme Court and its review over decisions relating to the occupied territories. I'm sure that everything that I'm going to say is quite familiar to my Israeli colleagues, but as we have a number of guests, a large number of guests from abroad, to set the context, it's very important for me to set out what the actual situation of the Supreme Court is. Now, as you know, Israel has been an occupying power, at least in the West Bank and possibly in Gaza and on the Golan Heights since 1967, almost 54 years. And there are at least three unique features about that occupation. The first, and that's the most obvious, is that it's gone on for so long. And in modern times, it's probably the longest occupation that we know of. But there are two other features which were more important and are very relevant to the present discussion. And the first is that from the very beginning of the occupation, the Supreme Court of Israel has exercised judicial review over actions of the military authorities and other authorities in the occupied territories. This, at the time, was regarded as being quite unique. There was no precedent beforehand for a domestic court of an occupying power to exercise judicial review over the actions of its military in occupied territory. Now, I want to stress, because in the previous sessions, a lot has been we've spoken a lot about compensation and criminal law. I'm talking about administrative review, judicial review over actions. We are not talking about criminal actions. We are not talking about suing for compensation. We are talking about review over actions of the military which are about to take place or have been taking place, where people petition the Supreme Court in an attempt to either reverse a decision which has already been taken recently or to stop some action or decision which is about to be made, such as demolishing a house. So that is the second feature of the occupation. We have the system of judicial review. The third feature is that while the territories are occupied, and I think that they're all foreign countries, all international institutions, and most of Israel's international lawyers regard the territories as occupied, the government of Israel itself has taken what, in the best terms, we could call an ambivalent attitude towards the status of the territories. The word occupied territories in the political arena is totally avoided. One could even say, to a large extent, it is somewhat of a no-no. And the government has argued in many fora that actually the territories are not occupied at the best. They're prepared to call them disputed territories. But the paradoxical thing is that while in the political arena, the government has refused to concede that the territories are occupied, when petitions come before the Supreme Court challenging actions of the authorities in the occupied territories, the normative frame for dealing with those decisions is ostensibly, and I say ostensibly, the law of belligerent occupation. And the government standardly argues cases before the Supreme Court on the basis of the law of belligerent occupation, trying to persuade the court that it is complying with the rules. Now, I say this subject to two important qualifications. The first qualification is that under Israeli constitutional law, customary international law is regarded as part and parcel of the law of the land, which will be enforced by domestic courts unless there's a parliamentary act which contradicts the rule in customary international law. But when it comes to treaty law is not enforced by domestic courts unless it has been incorporated in parliamentary legislation. And the reason for this is a constitutional reason, that the treaty-making power is in the hands of the executive branch of government, and therefore the courts have said, we cannot allow the executive to make laws by making treaties, and so unless Parliament has adopted the treaty, we will not enforce it. Now, when the first cases relating to the occupied territories came before the Supreme Court blindly applied the same constitutional law to actions from the occupied territories, saying that we will enforce customary international law, but when it comes to treaty law, we will not enforce it. Now, this becomes very important because when it comes to certain major provisions in the Geneva Convention, the court has said, well, we're not sure whether these are part of customary international law. On the other hand, the court has held fairly early on that the norms in the Hague Regulations of 1907 are part of customary international law, which will be enforced by the courts. So that is the first reservation as far as the application of the law of belligerent occupation. But there is a second qualification. And this is not that relevant in the cases that I'm going to be dealing with, but it has to be mentioned. The most controversial part of the government's policies towards the occupied territories, and the policy which has revealed most clearly the disparity between the law of occupation and government policy in the territories, is the project of settlement of Israelis in the territories, in settlements which are sponsored and built and created by the government. Now, of course, all of you know, those of you who deal with international law, that there are very strong arguments in international law that the establishment of settlements by the occupying power for its own citizens or own nationals in the occupied territories is a violation of the Fourth Geneva Convention and of customary international law. But the Supreme Court has refused consistently from the very beginning of the occupation to even consider this question. And in a leading judgment, which has now become the binding precedent of the Supreme Court, it is held that the question of the settlement project itself is not justiciable and the court will not consider it. It hasn't said that the settlements are lawful, but it has not said that they are unlawful. So now let's go down to the question with that framework, how is the court related to the protection of the family in occupied territories? And before going to the court's judgments, let's just look at some of the relevant legal provisions. There's Hague Regulations, Article 46, which says quite clearly family honor and rights must be respected. We have Geneva Convention 27, protected persons are entitled in all circumstances to respect for their persons, their honor, their family rights. And the ICLC study on customary international law in its rule number 105 says that family life must be respected as far as possible. Now, as you know, the generally accepted view today is that in occupied territories, the treaties, the human rights treaties to which the occupying power is a party also apply. And I think my colleague here, IHL Benvenisti, was one of the first persons to write about this in an article which he wrote many years ago on this question of the application of human rights treaties in the occupied territories. Now, that is what the International Court of Justice has said, that these treaties do apply in the occupied territories. The government of Israel has taken the stand that they do not apply for various reasons, which I will not go into. The court itself has taken an ambivalent attitude. It has never decided that the treaties apply. It has never decided that they don't apply. But quite frequently, it does refer to various provisions in this treaty. So they are relevant. And so we have Article 23 of the ICCPR, that the family is the natural and fundamental group, unit of society, is entitled to protection by the society and by the state. And the ICESCR, the widest possible protection and assistance should be accorded to the family. And we also have a preamble to the Convention on the Rights of the Child. I won't go into the various other provisions. So it is quite clear that there are specific norms which demand that the occupying power should respect family life and the family in the occupied territory. Now, I've mentioned the jurisdiction of the Supreme Court. It's dealt with thousands of cases. The normative basis for its decisions is, number one, customary international law, the law of belligerent occupation, the Hague regulations. It's never decided on the formal applicability of the Geneva Convention or whether all its provisions are part of customary international law. But in the last 20 years, the court has tended, as a matter of course, to cite provisions in the Geneva Convention. But, and this becomes very important, the court has also decided very early on that as the military commander in the occupied territory is a branch of the Israeli executive, he is subject to all the rules of Israeli administrative law, and that the court will judge whether his actions are compatible with these rules. So now, what about family life? Now, the family life policies and practices of the authorities that affect family life, I've placed them in two groups. The one my colleague Fionnuala Ní Eileán, who's going to speak to you tomorrow evening, dealt with in a recent article which he published in the Yale Journal of International Law. And that we mentioned security measures that certainly have a disruptive effect on family life. You may call it an indirect effect, but that is not their object. And there's roadblocks, restrictions on freedom of movement. We have a seam zone alongside the barrier, the separation barrier, which was built on the West Bank. And sometimes you have searches and arrests in family homes, which certainly are all disruptive of family life. But those are not going to be the subject of my talk. I'm going to be specifically mentioning measures which are directed at the family as such. So now let's see what those measures are. And I am going to, in this talk, mention four categories. The first, and in my mind, the most problematical and probably the most problematical part of the court's jurisprudence relating to the occupied territories, in fact, of the court's jurisprudence in general, is the court's jurisprudence on the use of punitive house demolitions, where certainly harm is caused to members of the family of a person who has committed an act, generally today an act involving violence which related in the death of another individual. The second is what has been termed by the Supreme Court assigned residence of family members. This was in a government policy which was adopted before Israel withdrew from Gaza. It's not really relevant anymore, in which it was decided that family members of people who had been involved in terrorist acts would be deported to Gaza, and then it was changed as a result of the intervention of the Attorney General that it wouldn't be any family members, but only family members who'd been involved in some way in the act committed by their family member. Then the third category is the question of using family connection as a basis of refusal of entry for people from Gaza, for medical treatment and for visits to prisoners. My colleague Yael Ronen will be speaking on Wednesday about the question of visits to prisoners. I will not speak about it this evening. And finally, we have the big question of family unification. To what extent are the military authorities bound to allow family unification of generally of a spouse and in the occupied territories? And to what extent has the court been prepared to intervene in the policy of the military in that connection? So let's start with punitive health demolitions, which in my mind, as I said, I think it's the most problematical chapter in the court's case law on the occupied territories. The legal basis for orders to demolish houses rests on a section in the British mandatory emergency regulations, which were promulgated in the whole of Palestine in 1945. If one were to read the regulation 119, one sees that it was actually tailored in order to allow the British Army to carry out reprisals, originally in South Africa and later in the 1920s in Ireland, because it is phrased in a very, very wide way that the military authority has the power to forfeit and destroy any house, even if I restrict it to that, if an act of violence was caused by a resident of that house. It's much wider. In fact, it says that they can destroy any house if a person in the village or the neighborhood committed an act of violence, but the Israeli authorities do not use that. They do use it to destroy the family home of an individual who was involved today in an act of violence which has caused the death of another individual. Now, in all of these cases, the person who committed the act of violence, very often a very horrific terrorist act, has either been killed, sometimes in a suicide bombing, is being captured and will be put on trial and generally sentenced to life imprisonment, or in a few cases has managed to escape and possibly even flee the jurisdiction. And the military commander then decides that issues an order to demolish the family home. Now, these cases came before the Supreme Court in the late 1970s. And at the beginning, for some reasons which are not quite clear, the court never even dealt with the principled arguments against the legality of this sanction in international law. It basically dealt with it on an administrative level and said, well, the power exists. We're going to have to examine whether it was reasonable to use it in these conditions, and we have no basis for saying that it wasn't. We're not going to intervene. But it didn't take long, of course, before lawyers started arguing before the Supreme Court the cogent arguments against the use of this sanction. Now, there's a tremendous amount of literature on this. Many of my colleagues and I have written about the illegality of this sanction under international law, and in the present context, I'm not going to be rehearsing all the legal arguments against the legality of house demolitions. The main argument which concerns us here is the argument of collective punishment, because the argument is that in all cases, the person who's actually committed the crime for which the sanction is being imposed has been imprisoned or is in many cases dead. And therefore, the victims are not going to be the person who committed the crime, but the members of that person's family. And in most cases, I wouldn't say in all cases, but in most cases, the person who committed the actual act was not himself. It's always a man. I haven't seen any cases in which a woman was involved. In all cases, in most cases, he wasn't even the owner of the house, was generally one of the sons of the people who owned the house. And of course, one of the big arguments was, well, if you're imposing it in these conditions, you are it's a form of collective punishment. You're punishing the family for the act of one of the members of the family when the family was not involved in the act. And I would say that the first decision of the court on the collective argument is one of the most embarrassing decisions of the court. It's embarrassing because the court purports to refute the argument against collective punishment, but actually confirms that we are talking about collective punishment. So what did the court say? And this is a case they call the Douglas case. And it says the object of Regulation 119 is to achieve a deterrent effect. And this effect by its very nature must apply not only to the terrorist himself, but also to those surrounding him, and certainly the members of his family who live with him. He must know that his heinous acts will not only harm him, but they are likely to bring great suffering to his family. From this point of view, the above sanction of demolition is no different from the punishment of imprisonment which is imposed on the head of a family, a father to small children who will remain without a supporter and a breadwinner. Now, the last part of the statement is a spurious total comparison between imprisonment and house demolition. Of course, the aim of imprisonment is not to create harm to the family. In fact, if we could somehow neutralize the harm caused to the family by imprisoning one member of the family, we wouldn't be frustrating the actual punishment itself. But as the court says, the actual object here is to cause some kind of harm to the family in order to try to deter potential terrorists or potential people who are going to use violence against using such or committing such acts in the future. Now, as I said, the aim of the sanction is to deter violence by harming the family of the perpetrator, but it does not lead the court to prohibit use of the sanction. And one of the arguments made over the years, okay, if the family was involved in some kind of way, then possibly you could have some kind of justification for destroying the family home. But if the family was not involved, then it's certainly a form of collective punishment and should not be countenanced by the court. In the 1990s, there was one judge who, as soon as he joined the court, accepted this argument, and he dissented from the views of the court, but his view was not accepted. And the view of the court became that family involvement is not a requirement in order for the military commander to be able to demolish the family home of a person who'd committed, admittedly, an extremely serious crime. For a number of years, between 2005 and 2014, a moratorium was placed on the use of house demolitions in the West Bank, following the views of a military committee, which has said, well, it's very doubtful whether it has any deterrent value, and possibly the hostility caused by use of this sanction outweighs any deterrent value, and anyhow, it's on the borderline of legality. And so a moratorium was placed on the use of the sanction, but in 2014, the government decided to renew use of the sanction, and then the court was flooded, but absolutely flooded, with petitions challenging the use of this in every case. To the court's credit, in every single case, it issues a temporary injunction to stop demolition of the house until the court has heard the case. But in the vast majority of cases, the court accepts the military's views that this is essential and does not interfere. Two judges on the court, Justices Mazuz and Kara, have accepted the collective punishment argument. There are other judges of the court who say that the court should reconsider the matter by an enlarged bench, but so far the Chief Justice has not been prepared to do so. So now let's see what this means as far as family goes. Well, the sanction itself is regarded by the court as being lawful. But in the 1990s, the court introduced a new idea. And it said, while the sanction itself is lawful when used in a specific concrete case, it must meet the proportionality test. The proportionality test, which has become the panacea in my mind for all the problems that the court has, it prefers to deal practically with everything that comes before it, rather dealing with questions of principle. It says, don't bother me with questions of principle, let's go straight to proportionality. Now, the proportionality principle has allowed the court to mitigate use of the sanction. And originally the court did so by saying, well, you can't destroy the house of an extended family. You can only destroy the house of the nuclear family. But then the court said, well, while family involvement is not a requirement, the military commander is entitled and is empowered to destroy a house, even if the family was not involved. He has to consider family involvement. It has to be one of his considerations, but we generally will not interfere if he considers it and decides otherwise. But the same proportionality principle has allowed those judges on the court who have very, very serious reservations about the legality of the measure itself to use the proportionality principle in order to rule in a number of cases that if there was no family involvement, use of the sanction would not be proportionate. And we had a recent judgment by the two judges I mentioned before, who happened to find themselves in the majority on a bench of three, Judges Mazuz and Kara. They said there was no family involvement in this case. The authorities didn't even argue that the family was involved in any way, and therefore use of the sanction in this case would be disproportionate. And I will deal with it a bit later. There was quite a public outcry against the decision of the court. The court in the moment is acting in an arena of intense hostility towards it amongst vast sections of the population, including those who have strong representation in the parliament and in the government. So how's the court? Now, one could ask yourself, our court has a fairly well-deserved reputation. It's a court which is fairly protective of human rights. How can we understand the fact that the court has been prepared to lend its hand to use of this sanction? And here I bring just one quotation from a decision of the court. The court said, notwithstanding and despite the legal reasons, it is morally distressing that the crime of the terrorist is paid for by members of his family, who, as far as we know, did not assist him and did not know about his actions. However, the chance that demolition or sealing a house would in the future prevent spilling of blood requires us to harden our hearts and to spare the living who are likely to become victims of horrific acts of terrorism, of terrorists, more than we should spare the tenants of the house. This cannot be avoided. In other words, the court says, well, we're actually trying to protect the right to life, and we have to deter potential terrorists. And if some members of the family have to suffer, well, that's the price that we have to pay in order to try to deter potential terrorists. And the notion of deterrence has become the theme of the court: deterrence, deterrence, deterrence. But the court obviously is totally worried by this. And so while they have not been prepared to rule that on the legal level, some involvement of the family is required, they have now gone on to the moral level and have tried to say, well, it's true from a legal point of view, it's not quite clear that the family was involved, but they had moral responsibility. And we see, I'll just give you one quotation. Is a fact worth mentioning, that in the entire petition, we did not find one word of reservation by any of the petitions in respect to the despicable murderous act that the members of their families committed. We did not find that any of them condemned the act or expressed shame that a family member had committed it. And we find in the judgment sometimes the judges have referred to the idea that the family was not involved, but they were not entirely innocent. In other words, they didn't condemn the act in any way. Okay, So now that is the question of house demolitions. Let me speak about assigned residence. Now, this was what was used before the Israeli withdrawal from Gaza. Once again, at a period in the early 2000s where Israel was faced with a host of terrorist attacks, members in the Israeli cabinet said, well, we've got to find some deterrent, and the best deterrent would be to deport family members of terrorists. And the Attorney General at the time said, sorry, this would not be legal. It is true that the Supreme Court of Israel has held that deportations out of the occupied territories are not contrary to international law, but that is not the view of the international community, and any deportation would be regarded by the international community as a violation of international law. And also he said there's no way that you could deport a person merely because he or she is a member of the family of the terrorist. The person must have some kind of connection with the act that was committed. And subsequently, following another wave of terrorist attacks, the government demanded that a legal basis be found for some kind of action against family members, and a military order was drawn up saying that the military commander had the power to order that any resident of the West Bank would have to move and live in Gaza. And at the time, although Israel had not withdrawn from Gaza, there was no freedom of movement between Gaza, the Gaza Strip, and the West Bank. So what happened then was that in the case of 3 persons, the military commander used his new powers and gave orders that they, as residents of the West Bank, would have to live in Gaza. Now, in all 3 cases, the members had in some way been involved in the acts which had been committed by their family members, which were in all 3 cases pretty horrific acts. And when the case came to court, the court had to deal with a number of questions. And the argument of the petitioners was this was a form of deportation. It was also a form of collective punishment because they were actually punishing the family members for the acts of their family members. And the court rejected both arguments and said, no, the people are being deported because they were connected with the acts. And in order to stress this point, it's very interesting. There were 3 petitioners in the case. The court examined the evidence in all 3 cases and said the evidence of the actual involvement of 2 of these people was strong enough to allow some sanction against that person himself or herself, it was in one case. But against the 3rd person, the involvement in the act of his brother was not strong enough, and we cannot accept this. But the court also said, we are not talking about a situation of deportation. Gaza and the West Bank were regarded by the court as being part of the same occupied territories. The court relied specifically on a section in the interim agreement between Israel and the PLO, which said that Gaza and the West Bank would be regarded as one territorial unit, and therefore the court upheld the actual sanction, but made it very, very clear that it could only be used if there was a very strong connection between the person being deported, as it were, from the West Bank to Gaza and the act which led to that person's deportation. So while the person was a family member, the actual family connection itself was not sufficient to justify the move. Sorry about that. Now let's just go. So after Israel withdrew from Gaza, the Israeli government argued that Gaza was no longer occupied territories. It's a matter which is controversial. Some international lawyers still believe that Gaza is occupied. Ayal Ben-Benishti, and I think quite correctly in his book, takes the opposite attitude. I also agree with him that I do not think that Gaza is occupied, although I don't think that Israel can say that it has no obligations towards the people in Gaza. And that fundamentally has been the attitude of the Supreme Court, while it upheld the Israeli government argument that Gaza is no longer subject to Israeli occupation after the withdrawal of the IDF and Israeli residents from Gaza, but still Israel retains certain humanitarian, what the court says, commitments towards the residents of Gaza. Now, in Gaza, for many years, the medical services were not very developed, and people, especially people suffering from certain severe diseases, treatment for cancer and other diseases, were coming into Israel or to hospitals in East Jerusalem or in the West Bank in order to get medical treatment. And after the Hamas refused to return the bodies of Israeli servicemen who'd been killed in military operations in Gaza, the government decided not to allow entry to Israel for medical treatment of family members of senior Hamas officials in Gaza. So this was clearly an act which is directed specifically at family members as family members. The Attorney General once again stepped in and said, first of all, the mere connection itself cannot as such be a strong enough reason, and it certainly cannot be used in a case where you have life-saving treatment. But anyhow, we had a case in which there were 5 women from Gaza who were family members of Hamas operatives who required medical treatment that was not available in Gaza. It was available in hospitals in East Jerusalem, which under Israeli domestic law, not under international law, is regarded as being part of Israel. And the government applied this policy and said, we are not allowing them entrance into Israel because they are members of the Hamas. We have to pressure the Hamas. And they went to court and they produced evidence from a leading Israeli physician, expert in cancer, who said it was desperate. These women needed the treatment immediately. They could not get the treatment on the West Bank or in Gaza. They could not go abroad because, first of all, it was expensive and they needed it immediately, and they should have the treatment close to their homes in Gaza. The court was very, very uncomfortable and said to the counsel of the government, go back and ask the Minister of Defense whether he's really prepared to stand behind this decision. And when they came back and said he was, the court intervened. And they were not prepared to intervene in the policy itself, but they once again used the proportionality test in order to say that in this kind of situation where the lives of these people were in danger, it was not proportionate to the legitimate interest in pressuring Hamas to return the bodies of Israelis, to deny them the medical treatment that they needed. And the court gave an order to the military authorities or to the Israeli authorities to allow entrance of these 5 women to receive medical treatment in Jerusalem. The last question, and I have a few more minutes, I'll just end with this, is once again is the question of family unification. Now, international law and the Geneva Convention does have articles concerning families who've been separated by war and encouraging reunification of families. But the occupation of the West Bank has gone on for almost 54 years. We're not now talking about reunification of families who were separated by war, but what happens when people from the West Bank get married to somebody who is not a resident of the West Bank? To what extent is the person who's a resident of the West Bank entitled to demand that his or her spouse be allowed to live with them on the West Bank? And the court dealt with this question in the 1980s, and it decided on a basis of principle that the occupied territories had been declared a closed area, that as it was a closed area, there was no obligation to allow family unification in the area. It also said that neither international humanitarian law nor international human rights law recognizes the right, the duty of a country to allow persons to come into the country in order to live with their spouse. It does demand that countries allow people to leave for family unification. It does not demand that they allow people to come into the country to join their spouses, and therefore the court would not intervene with the policy. Now, of course, this decision, first of all, was held in the 1980s. It's a highly problematical decision in my mind, because while the court, once again, as it has done in all other cases, upheld the actual policies, it didn't even judge the individual cases to decide whether the commander's decisions were based on reasonable grounds, whether it was based, the court has decided that in occupied territories, the commander must be direct himself by two considerations, either military considerations or the welfare of the local population. They didn't examine whether he'd done so in this case. And the court has not been responsive to articles since then. It's kind of quoted basic Israeli interests without mentioning them. And furthermore, and this to me is a very, very essential point, the court latched on to a formal order of the military authority declaring the occupied territories to be a closed military area. But in actual fact, of course, it's not a closed military area, because it is totally open to all Israeli residents and nationals, and all tourists who come to Israel. And so here we have an example, I think, of a dual standard, that the territory is declared closed when it comes to Palestinians, but it's not closed to anybody else. I don't think that can be justified. I want to conclude now. Let's see something about about the court. The court has avoided arguments of principle. The family unification is an exception. The court dealt with the argument and dismissed it. But as I said, the decision of the court itself is highly problematical. The court has always accepted government policy, even when it's highly problematical, as it is clearly in the government policy to use house demolitions as a deterrent. It's only prepared to examine whether the implementation of the policy in individual cases actually meets the demands of Israeli administrative law, and most specifically, the principle of proportionality. Having said that, I must now say something a bit wider. I started off with some words about the Israeli Supreme Court. And the question that I ask at the end of my paper, and I am not going to deal with it at length now, is what can we learn from this about international law, international humanitarian law? And the truth is very little, because the court has either avoided dealing with the issues of international humanitarian law, it's either avoided them altogether, or when it has dealt with them, as it tried to do so in the cases of the punitive house decisions, I would say that its decisions leave a lot to be desired. And I'm being pretty generous to the court when I say that. So what can we learn from it? Well, we can learn about the limitations of domestic courts which operate in a specific political arena. And what we have to realize is that it seems to me, and I don't know if Ayal's going to agree with me, but it seems to me that in recent years, many of the judges on the court have serious reservations about quite a lot of the decisions of principle which have been decided earlier on in the 1980s and 1990s. And the question that now bothers them is, are they in a position to reverse the stand that has been taken by the court 20 years earlier? And they are faced by two binds, I would say. The first is a domestic political bind. In the 1970s and the 1980s, even in the 1990s, the court was a prestigious institution which enjoyed large public support. That is no longer the case. The court is an institution which is under tremendous attack, and not only from fringe elements in the Israeli political scene, but from people central in the Israeli government. One of the parties which ran for election in the last elections and who will probably be a main party in the next government, they ran on the platform that returned power to the people from the High Court. So number one, it seems to me quite clear that if in 1979, when the first demolition case came before the court had said, are you crazy? You can't use this. It's totally contrary to international law. It's contrary to our own values. You've got to find some other way to protect security. It would have been accepted. If the court were to do so itself, the reaction to the court, I would say it could even be violent. Even after the last decision in which two judges on the court ruled that in the specific case, use of house demolitions would not be proportionate because there was no family involvement. One of the ministers of the government already said, we've got to give the court a red card. It's not acting according to the values of the state of Israel, which is a pretty unfortunate statement. So that is the first constraint. The second constraint, and this is important for us to remember, is constraints in international developments. The prosecutor of the International Criminal Court has said that she will be opening a criminal investigation to the situation on the West Bank since 2014. And clearly some of the questions that I've dealt with here are potentially questions that could come before the International Criminal Court. And then we've got to ask ourselves, well, what is the domestic court going to do in such a situation? We've always hoped that the very existence of the International Criminal Court would serve as an incentive for countries to comply with international law and make sure that their domestic courts enforce international law so that they, by the rule of complementarity, they won't have to get to the International Criminal Court. But here we have the opposite situation. If the cases are now going to come before the International Criminal Court, can we expect a domestic court to give them some of the weapons which they may use in the future when they want to prosecute Israeli military or political leaders? And so the court has taken the easy line. Rather than dealing with the questions of principle or rethinking the questions of principle, it tries to mitigate the use of the policies by placing the emphasis on concrete cases. The legal reasoning on IHL and IHRL are weak or conspicuous by their absence. That is absolutely clear. But we are dealing with a domestic court. And unfortunately, if I really want to be realistic about it, the best that we can hope for in the present situation is for the court to be a bit more forceful in interfering in individual cases. We are not going to see the court interfering in the policies which I've dealt with. Thank you very much. Yeah, I can't hear you. What is it?
Sorry. Thank you, Professor Kretsmer, for this comprehensive and rigorous lecture as usual. I'm fortunate to be both the chair and the commentator. So the chair will not prevent the commentator from commenting, but I'll invite people who wish to ask questions to use the participants in this conference to use the chat function, ask or indicate the wish to ask, and I will call on them. And then members of the audience, if you wish to ask questions, you can use the Q&A function, and we might extend the Q&A beyond 8 o'clock if needed. I have this authorization. Before commenting on Professor Kretsmer's paper, I wish to pay tribute to his determined and rigorous efforts spanning 4 decades to explore the discrepancies between the requirements of the law of occupation and their implementation in practice. Taking the Israeli Supreme Court to task for its treatment of the law of occupation was at that time a rare act of selfless courage among Israeli legal academics. In his writings and by his involvement in public affairs, Dave has inspired me and many of my colleagues. He was a model of an involved scholar who maintains personal integrity and is not afraid to speak truth to power, including to the judicial power. Reflecting on Pretzmer's oeuvre, it clearly marks a shift in Israeli public law scholarship on matters subject to international attention towards critical engagement that is driven by deep commitment to human values and to democracy in Israel. With respect to this paper, I have 4 small points, 2 on the role of the court and 2 on substance. With respect to the role of the court, one comment concerning the standard of review, and Professor Pretzmer rightly points out that the court reviews the action by the military in the occupied territories as exercised under the court's jurisdiction as a high court of justice, and therefore examines the legality of the executive action, and it does not sit as a court of appeal. And this obviously limits its authority to examine the lawfulness of measures as if it was the institution to make the decision. This attitude may be right from the perspective of Israeli domestic administrative law, but it is patently wrong from the perspective of international law. There may be other reasons for deference from the perspective of international law, but they would not exist in cases where one party is exercising authority beyond its territorial jurisdiction over non-citizens. But perhaps there is a different approach that can also be ascertained from some of the judgments of the Israeli Supreme Court, and in fact, I agree that they are rare, but there is that alternative attitude that is offered by some of the latest judgment of the President Barak in the famous Bet-Surik case and the targeted killing case. The Bet-Surik case with respect to the separation wall or barrier, the court makes the point that the question of proportionality is not a matter for the military commander to consider. And I quote, "The question is not whether the military commander believed in good faith that the injury is proportionate. The standard is objective. The question is whether, by legal standards, the route of the separation fence passes the test of proportionality. This is a legal question, the expertise for which is held by the court." So this perhaps was a way to redefine what is legal in order to increase the court's discretion, ability to intervene on this matter. With respect to the flexibility of the court and the pessimistic outlook concerning house demolition, Professor Kressler asked, were the court to reverse its approach, would it be confirming part of the elements of this offense? It seems that the court has painted itself into a corner. I agree, but perhaps there is a procedural way out. And this relates to the moratorium that Professor Kressler mentioned concerning the sanction of house demolition that extended between 2005 and 2014, following a report by a committee headed by a general. Now, perhaps it is interesting to note that that committee was set up after 2 judgments of the Israeli Supreme Court hinted that they are not certain about the efficacy of house demolition. So there's one judgment by Justice Dorit Beinish, Abu Salim, and I translate, "We will not interfere with a decision of the military commander that is based on a substantiated assessment." In Hebrew, ha'acha mevuseset. Substantiated assessment of its likelihood to lessen the murderous activities and are, in the commander's view, necessary to contribute to safety and saving human life. We will not interfere, but we will not interfere with a substantiated assessment. And this was rendered on the 2nd of October 2003, and about 2 weeks later, another judgment came from Judge Orr, which says how demolition is an extreme act, and it is appropriate that the security services consider from time to time the appropriateness and the effectiveness of these assessments. So this was a hint in instruction to reconsider, and this is what led apparently to the reappraisal, which was not more than window dressing. So the court has its indirect ways to end illegal practices without admitting responsibility. 2 points on the substance concerning the duty to protect family and the principle of distinction. The paper rigorously addresses the different provisions of the Geneva Convention and the Hague Regulation concerning the protection of family members. And I agree, of course, with all of them, and I would add or offer the possibility that all of them are actually covered by the broad umbrella of the principle of distinction. The principle of distinction that extends beyond the battlefield, beyond Article 52 of the Additional Protocol 1, is reflected in a general customary law obligation, which is also rule number 1 in the ICRC CIL project, namely that parties to the conflict must at all times distinguish between civilians and combatants. Now, to the last point, as to the prevention of medical treatment from family members, and Professor Kressmer rightly is concerned about the fact that the guiding legal norms are left indeterminate, thus allowing the authorities wide discretion in practice and forcing those affected to challenge individual cases in court. I would add that this practice leaves open the possibility of conditioning medical treatment with collaboration with the IDF or the security services, which is apparently prohibited under Article 31 of the 4th Geneva Convention, which provides that no physical or moral coercion shall be exercised against protected persons, in particular to obtain information from them or from third parties. And that particular provision was mentioned by President Barak in the Adala, then the case of 2005 early warning procedure or human shields, stating that the civilian population is not to be used by the military needs of the occupying army. And moreover, apparently this practice is inhuman and degrading treatment, if not torture. These were my comments, and I welcome now comments from the audience, if there are any. Otherwise, we are close to 8. David would like to.
Thank you very much, Ayal, and thank you for your kind remarks about me. I could return the remarks about Ayal in the same vein, but in order not to embarrass him, I'm not going to say what I really think of his contribution has been an absolutely tremendous contribution to the thinking about international law in Israel, in the occupied territories. He's one of the first persons who wrote about the whole question of 2 legal systems applying as far as the West Bank goes, a long time before he became a famous professor, Ayal Ben Benishti. So thank you very much for your kind remarks. And now let me say something about your remarks, which I thank you for, and very perceptive and interesting remarks. As far as the role of the court, I totally accept what you say. And I've always thought that the notion of the court as regarding itself as merely an administrative court is misplaced. And it's misplaced even when it comes down to the distinction that the court has made between customary and treaty international law. That should not be relevant when it comes to occupied territories. That is an internal constitutional law which applies in Israel. The people in the occupied territories are not part of the political community. They cannot affect decisions in Israel itself. And so there I quite accept that the actual position of the court, if it's going to review actions of the military, should be a much more rigorous review in which they should apply all the rules of international law. But of course, that was not the view taken by the court, and the court is now acting under domestic constraints. Now, the second question is a question which really bothers me, and that is, well, could the court have reversed its stand? And I think that IHL is probably right, that if immediately following the moratorium, in the first cases that had come before them, when the petitioners argued there's a moratorium, you can't start renewing this act again, the court would have said, yeah, you're right. You've stopped it, you can't start it again, but they didn't do that. And once they didn't do that, because there were quite a few serious terrorist acts, the court reversed and said, no, the authority exists. And since then, I think my colleague Guy Arpaz has counted over 100 cases, and he counted it 2 years ago, a year ago. Amichai is sitting here, he also has written about it, and possibly even more cases that have come before the Supreme Court since then, in which the Supreme Court has upheld the legality of it. And so I do not see that they really have retained for themselves the flexibility in the moment of reversing their view on the actual legality of the sanction. The most that can do is to widen the notion of the interference in individual cases by using the principle of proportionality. Like no family involvement, it's not proportionate, and they could even do it in other cases, as well as in 1 or 2 cases they've done in which they said, well, in this case, because of the facts, it's not going to have any deterrent value, and therefore it would be disproportionate to use it. It's interesting that in one case, the persons, the families of the victims of the act which had led to the decision of the commander to destroy the house of the Palestinian family asked to join the proceedings, and they, of course, demanded that the house be destroyed. And Justice Naor was then the Chief Justice, said, you know what, you're looking for retribution. That's not the view of this court. We're not talking about retribution, we're talking about deterrence, and in this case, it wouldn't have any deterrent value, and so it would not be proportionate to overrule it. So the court could start widening it, but as we all know, there's a tremendous amount of division on the court. And there are 2 judges who are prepared to do that in practically every case. There are 1 or 2, 3 other judges who, in some cases, are prepared to go along with it, not always. And so, unfortunately, we've come down to the situation, and it's a very unhealthy situation for the court, that if you're a Palestinian petitioner and you're petitioning against the demolition of your house, your chances of success are going to depend on which bench you're going to meet. If you have a lucky day and you're going to meet a bench with Justices Bazuz and Kara, and possibly with Justice Baron or Fogelman, then you may be able to get a remedy. And if you're going to go there and meet the other justices, especially if you're going to have Justice Solberg and Justice Mintz, then you have no chance. So now, okay, then I agree with you that in some ways the court has changed, but I wouldn't see it in Barak's judgment. I think that the biggest change has been in 2 judgments, one of which Amichai wrote about, and that is the Ziada case of the decision of Justice Jubrani's last decision on the court, in which he suddenly exposed the fundamental discrimination on the West Bank between the Israeli settlers and the Palestinian residents. But I would say that the two recent cases of the president of the Supreme Court, Justice Hayot, her decision in the case regarding the settlement regularization law, in which she overruled a law of the Knesset which purported to expropriate the land, private land of Palestinians on which Israelis had built houses. And it showed a very different view of her view of what the occupation was about, in which she spoke quite clearly of the inherent inferior situation of the Palestinians who are not represented in the Israeli politic. And I would say that her latest decision in another case, in the Mitzpeh Kramim case, which also showed a different view, that she was prepared to apply the rules pretty vigorously in order to stop government action. I hesitate to say it, but I'm not sure that the judges who were on the court 20 or 30 years ago would have reached those decisions. Now, where that can lead the court, I'm not sure, given the constraints that I've mentioned. But when it comes down to family members, I still think that their only chance is trying to get through the loop of proportionality. Thank you very much.
Thank you, Jay. There's one question still unanswered. This is by Professor Yuval Shani. And I'll read it. Do you agree? So, excellent presentation, Dave. Do you agree that the house demolition decisions illustrate the problem of path depending? It is very difficult to change course, especially when political conditions become more tense for the court. And that this is a major explanation for the difference between the house demolition and the medical treatment decisions. And whether you think that an earlier acceptance of international human rights law would have prevented the house demolition cases from developing in the trajectory that it did.
Well, number one, in my paper, which Yuval hasn't seen, but which IHL saw, I wrote exactly that. Yes, I do believe that once the court had made a decision, I don't think one decision. After it had made one decision, it could reverse. But when it has, for 40 years, the first decision was in 1979. So what we're talking about is from 1980 to 2000, 40 years, it is said that it's lawful. It's what I said in the paper. It's painted itself into a corner. And it is for the reasons that I said, I think for domestic political reasons and because of the International Criminal Court and possibly because of universal jurisdiction of other courts, it would be very, very difficult for the court to reverse its principal stand. What it could start doing is trying to cut down the use of the measure, like saying, well, you haven't proved that it's effective. They demand each time that they show that it's effective and that this is not disproportionate. They're not going to rule that it's totally unlawful. That's number one. I must admit, and this Yael and I wrote in the book, which will be published soon, whether it would have made any difference if they would have applied the norms of international human rights. And I'm afraid to say that I don't think so, because the problem wasn't that there weren't norms. The norms were there. If you wanted the norms in international humanitarian law as far as demolition of houses is even stronger, because there's a total prohibition on demolition of houses except for imperative reasons of military operations. So if the court had wanted to find a legal way of interfering, the way was open to them. So it wasn't the lack of legal norms, it was the lack of the willingness of the court in this kind of situation to really take a view that their duty in the occupied territories is to rigorously enforce international norms. And so I would have assumed that if they would have come to the international human rights norms, they would have said, yes, of course. But we know that there's a limitation clause and this meets the limitation clause, and they would have, I don't think it would have changed the result.
Thank you. I think time is up. So I want once more to thank our teacher, my teacher, Professor David Kreismer, for his wonderful lecture, keynote speech. And I wish all the participants interesting discussions in the coming days. Thank you very much, Dave.